methodology continuing is a clock, my lord. 2015, he was given some benefits. Now 2024, they have issued a notice that you have taken this amount excess, please and order for recovery, madam.
Now matter is pending here.
No, first case, madam.
First time.
Again. And one day, madam, so that no recovery can be given.
After
notice matters. All admission matters, fresh matters.
One fresh matter transfer.
1 second. Give fresh matters.
This is a fresh matter.
Give that.
Transfer there. One day.
Admission matter, madam. Admission.
Yes, fresh matter.
No, after notice.
After notice. After move it on Monday.
It is orders matter. It was on the 4th of this month, my lords. Your lordship specifically directed to list this matter next week. Inadvertently, there is some mistake in the order, my lords. Instead of next week, it has been mentioned as next week of September. It will never come, my lords. I am just praying, my lords. Next week orders matter.
No, they have understood.
This is a review matter, my lord. Challenge the against order of FO matter. Now this is a covered matter, my lord.
Next week.
One pension matter, my lord, is a bad read and it's 73 euros old. It can be next week.
Termination matter, 2 weeks after. Second week,
third week of
don't to mention. Second week.
Third week.
Pardon to mention, my lord. That first matter, my lord. The opposite party.
No, first matter, it will come.
My lord, this is an after notice matter, my lord. This is an after notice matter. Although the criminal proceeding has been concluded in acquittal, my lord, no pensional benefits are being paid. Although it's a matter of 2024, it is not getting any.
One matter, my lord, transfer. Yes, disabled person has been posted on the recommendation.
One day we will have that.
But today, my lord, always she will be relieved. My lord, person kindly take up today, my lord.
Today, why?
My lord, he will be relieved, my lord. He has been posted disabled person locomotive disability with the 60% disability. He has been posted on the top of a hill within the Shripad National Park, my lord. 30 kilometers to walk, my lord. If he is relieved, my lord, he will be known.
Maybe because his disability will vanish if he climbs the hill.
No, my lord, locomotive disability.
Locomotive
Format is disabled.
at 2 o'clock.
My lord, after notice pension matter.
It's 2 weeks.
Lord, I have given memo earlier, but it could not be listed.
See, when memos are given, post the matter. Right? Yeah.
Pardon to mention matter, my lord. Item 22, my lord.
Item 22.
My lord.
Which year, man?
2013 matter.
2013.
Matter. Mr. Ratha is on.
Wait till matter reaches. Yes. Number one.
May please, your lordship. Last occasion, your lordship had asked me.
Your
Senior my lord.
Lordship was suggested that the press committee be appointed so that they can evaluate the marks again. But then the difficulty is board doesn't have a controller now. Yes, new controller has been appointed. He is yet to join. So Lords may call it after 10 days so that something can be done.
We'll do that. Call up. Give 1 week after 2 weeks. No, he is posted.
Posted, appointment has been already given. He has to join.
But he asked you to, or you ask him to join.
How can I? A new person is joining. New controller is appointed. He will be joining.
I will make an observation.
Moish.
It is submitted by Mr. Rao, the senior advocate, that the new controller is taking, assuming office, and therefore matter may be called after 10 days. Personally, the new controller is requested to assume office at the earliest. Okay. Panel comes, Mr. Rao to communicate this order to the said intending incumbent. Item 2.
Giving a date,
Can we call that matter on 12th of Yes. On 12th or 9th? 12th.
Better 12th.
Item 2?
May I please, Your Lordship? Lord, my application for legal heir certificate has been rejected,
Rejected.
my lord,
On what ground?
on the ground that even if all the records shows my parentage as one person, but there is no deed of adoption, so I must approach the civil court. That is the finding of the Tahsildar.
You claim as an adopted son.
Yes, my lord.
How to prove the adoption either?
My lord, all the documents are in the name of my adoptive father.
Adoptive father.
Yes.
They say you are adopted. Do they say that they are adopted? You
Yes,
are
my lord.
adopted.
The inspector the revenue inspector in his inquiry report says that he is adopted, but there is no document of adoption.
No, the document, it's adoption is a serious thing.
My lord,
Because
my lord, my
succession and other things will arise. Therefore, you have to go to civil.
my humble submission, this is a certificate issued not for succession. This is a certificate issued for limited purpose.
Correct. That purpose also.
And there is
Because you will be treated in the whole village and the officers that you are the legal heir of a deceased person.
my lord.
And therefore,
And he is issueless. The person,
we do not.
my lord, the inquiry report and my humble submission, the rule says only in case of dispute it is to be referred to the civil court. Here no objection is filed by anybody.
But they have given a cogent reason.
My lord, my
There need not be dispute always.
that is the
Dispute itself has undergone change. If you read Wade's administrative law, Wade and Forsyth, earlier, for a dispute, there used to be X versus Y. It need not be that way nowadays. There are such judgments, English judgment, which Professor Wade discusses. There are judgments. Only thing you have to turn the pages of the book which the judge is telling you. Otherwise, I have to bring that and hold you to you.
no, I will.
That will be embarrassing to you. You are a senior person.
No, my lord, I will make further research because
No, nothing, no research.
my humble
But I have made all research all these years. Therefore, you have to go to civil court. We will say if you go to civil court will decide the issue at the earliest.
my humble submission, the difficulty I will face in the civil court because there will be no defendant now.
Why there should be a defendant to go to civil court?
And if I go for a suit,
Yes.
then
You arrange these people, the officials.
my lord, for establishing adoption, impleading these officers,
Yes. Because they said we don't agree with your version. So you have a cause of action.
I have a doubt there whether I can implead them as defendants and seek a
They
declaration.
can be made defendants. They become proper parties. It's not necessary parties in the light of apex petition in Rajia Begum, AR in 1958 Supreme Court.
Come next week, I will just examine on these as because I have no contestant there. That is
We have said that. But the grievance of the petitioner is very received against the order dated 8/5/2025, whereby he requests for issuance of no, not 8/5.
not 11/3.
11/3/2025, whereby is a claim for issuance of legal heirship certificate has been negative by the respondent or OPs, jurisdictional OPs. First, kindly be seated. Learned counsel appearing for the petitioner vehemently argues that there is an observation that the petitioner happens to be the adoptive child of the deceased, and therefore, on that basis, the claim ought to have been favored first of all. He also adds that unless there is a comma, ordinarily, the request for issuance of such certificate should be favored first of all. Next paragraph. Anything, Mr.
Succession certificate.
Huh?
That is succession certificate, the rule says, under the Indian Succession Act.
But this is airship certificate.
No, when the rule says, provided that in disputed cases, the applicant may be advised to approach the competent civil court for issue of succession certificate.
Correct. Yeah.
Then,
No, that is not applicable. This is version because I am asking for a succession certificate. Anyway, learned AGA Mr. Lenka on request appearing for the OPs opposes the petition contending that disputed fact matrix is involved apparently from the record and that there need not to be an opponent to have a dispute. First, dispute may arise even without there being an opponent if the authorities who are treating the claim of the kind shall be in future bound by that certificate itself, which will have several consequences. First off, next paragraph. Having heard the learned counsel for the party and having perused the petition papers, this court declines indulgence in the matter, broadly agreeing with the learned AGA appearing for the OPs. First off, it is not that one should approach the court only when there is a dispute in traditional sense. First off, the CPC provides for approaching the court even without an opponent. First off, to give an immediate instance, the probate is sought for in cases even in the absence of an opponent. First off, of course, if there is an opponent, invariably it would undergo the transformation of a dispute. First, another instance is of interpleader's suit, which order in the CPC, interpleader's suit. A person can go to court and say this item belongs to particular so and so, I want to give it to him and give the decree. There are such provisions in the CPC. Okay. First, next paragraph. First, therefore, the contention that to have a dispute, there must be a disputant from the other side may not be always true. First one. Next paragraph. It hardly needs to be stated that the legal heirship certificate will have its own prima facie efficacy for the purpose of issuance of ration card, voters list, state benefits, etc. First off, therefore, one cannot assume that the certificate is innocuous and therefore that can be distributed in the marketplace as and when people ask for that. First, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to approach the appropriate forum for further redressal of his grievance. First, in that connection, all contentions are kept open. Next paragraph. Regard being had to the urgency pleaded in the matter, if petitioner files a suit or appropriate proceeding, the presiding officer of the forum is requested to try and dispose of the same at the earliest, as early as possible. As early as possible. No. Next. Yeah.
Okay, my opinion. Well, it's the petitioners have challenged the arbitrary action.
Can any youngster give the provision of CPC in an interpleader suit?
Yes, Section 88 and Order 35.
Order 35.
The court may act as plenty for defendant. Depends on
Order 35.
35.
Is it 35?
35.
Ah. Don't get embarrassed when I ask this question. I will be asking because I will not be knowing, and I will also learn along with you. That way. Okay. Yes.
Yeah, please. The petitioner has challenged the arbitrary action of the opposite party state, whereby there's a scheme called Godabarish Mishra Adarsh Prathamika Vidyalaya, GMAPV scheme.
Vidyalaya scheme. What this provides for?
Provides for, let's turn to Annexure 1. This is the scheme. Page number 14.
14.
14.
Ah.
So in this scheme, the scheme shall be implemented through Odisha school education. The total number of students of schools will be covered throughout the state. But this scheme will increase the infrastructure, provide better facilities
to the institution,
to the government schools. So one government school in the entire Gram Panchayat is selected for this purpose.
Okay.
Entire Gram Panchayat, one government
as a pilot project.
Sorry?
As a pilot project.
Pilot project. It's a pilot project.
Ah.
So currently one, and the criteria laid down under Annexure 1 states that the school should be situated at the headquarters of the Gram Panchayat. It is a mandatory criteria. School should be situated at the headquarters of the Gram Panchayat. But my lords, in the present case, the opposite parties have, instead of selecting this
headquarters school.
Yes, my lord. Instead of selecting the UPS Sanpodaguda is the headquarters of Podaguda Gram Panchayat. Instead of selecting that school, they have selected another school of another village. That is upper primary school of Negiguda village.
Who are you?
My lords, we are the petitioners here. Our children are studying in UPS Sanpodaguda. So that for that instance, on the last occasion, this Honorable Court had directed us to file an affidavit stating therein that our students our children are studying in that school, UPS Sanpodaguda. In that regard, we have filed an additional affidavit where we have annexed the documents from the.
Where is that? Read that policy, the scheme policy, how it runs. That
the Annexure 1 minutes.
Yes, where it says it should be.
14. My lords, I'm placing this. Para 4. School should be selected based on the following criteria. Number 1. The school should be preferably
situated in GPA.
My lords.
Word preferably takes care of the decision.
The word should be given preference. Preference should be given to the Gram Panchayat headquarters.
Preferably.
My lord, they have a discretionary power here. I understand, my lord.
As much as possible. That.
Other criteria are also not fulfilled. This is one criteria. There are more criteria. My lord, turn to page 15. Page 15, criteria number 4. School having highest enrollment strength may be considered on
period. Maybe how the wording of these things. They have used the policy is crafted with English language. Okay? So there, and it is not a statutory policy.
It is a government.
Every government policy is not a statutory policy. It need not be. You have seen the petition in Javaya Kapoor.
It is not a statutory policy.
It's an executive
decision. But
it is not intended to create any right in your favor. The case of Balfour versus Balfour. Can anybody take out that judgment? Balfour versus Balfour, where the contract is not intended to create legal right in anybody. Similar provisions are applied by the apex court of our country to cases like this. It does not create any interest in your favor.
Yes,
no justiciable right in your favor.
But in this regard, my lords, we had filed a grievance petition before the collector.
Let them consider.
No, they have considered. I have annexed the document. They asked the district education officer to conduct an inquiry. And after inquiry, my lords may kindly have
rejected.
Yes, my lord. They have rejected it. The grounds they have stated in the rejection.
No, worry, what is your right? Under the policy, where is the justiciable right given to you?
My lord,
it's a condition, is not a right.
That they are taking
the government to function.
The grounds taken by the DEO is regarding the conditions only. They have taken into consideration the criteria and thereafter rejected. Which is wrong.
This court says that you have no justiciable right at all. Balfour versus Balfour which Anson on contracts refers to, is a famous judgment. Can anybody tell the citation? Must be 1800 and dot.
1918.
1918.
Welfare versus welfare. All England report 862.
That's things. Where certain arrangement is not intended to create justiciable right, one cannot complain that.
Justiciable right is, but our right has been affected here.
Kindly sit down. Kindly sit down. Petitioners, being the villagers, claim that their children are studying in a particular school which is situated in the jurisdictional limits of Gram Panchayat, and therefore that school alone should have been taken as the beneficiary under the government scheme dated 15 to 2025, a copy whereof is at Annexure 1. Next paragraph. Learned counsel for the petitioner, taking the court through the contents of the said state policy, vehemently argues that the school now chosen under the scheme as the beneficiary is not situated within the headquarters limits of the Gram Panchayat concerned, and that it also does not satisfy the clause 4, Roman 4 of the policy, in as much as it does not have highest enrollment of students. First, that being the position, counsel submits that the rejection of his representation by the impugned order to choose the school of his children for the benefit under the scheme is alterable. First off. Next paragraph. Learned, what do you say? Everything I have said now.
Yes, sir. Now,
Want to add anything?
the rejection has been made on the ground that as per the guideline, one school in from one GP will be selected, and the where the roll strength of the student is higher. So the petitioner's school roll strength was 200, and the school selected for that it is 205. So for that reason,
205.
that is in the annexure 4, page 20 of the.
That is what we have stated in this writ petition, that they have stated this ground that the village Negiguda school has higher enrollment. But that is outdated data, and for that reason we have filed Annexure 5, wherein it is stated that in the present year of admissions, our school has
More number of students.
well, it's
How many students?
our school has 230 students, while the other school, 232 students, while the other school has 226 students. So in that ground, we have more students, and we are fulfilling the criteria on their own.
232. There is 226. 26. So 6 students are less. Next paragraph. Learned AGA, Mr.
That
Lecter,
additional affidavit is not available.
appearing for the OPs, resists the petition, contending that the policy of the kind is not of statutory origin, and that it is not intended to create any justiciable right in anyone. First, the norms have been laid down so that the discretion available to the authorities is not violated by making whimsical choice, although he should. First off, he also submits that the student strength, the pupil strength in the school now chosen is higher than that of the the school which the petitioners are pointing out. First, so contending, he seeks dismissal of the writ petition. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court declines indulgence in the matter for the following reasons. A. Firstly, the policy in question is not a statutory policy, but has been evolved in exercise of executive power availing to the state under Article 161 or 162 of the Constitution of India. First up, ordinarily, the policies of the kind do not give any justiciable right to the so-called aggrieved persons. On line with Pulfar versus Pulfar, 1918, All England Report. Just write down and give that. So 816. Asking some birth for Pulfar. 19 2 KB 571. 860. No, Pulfar 1919 2 KB King's Bench versus 571. 571. First one. The apex court has also discussed similar matters, nature of similar policies evolved in the exercise of executive power in the case of Sahib Ram Javaya Kapoor versus State of Punjab. Anybody can give that citation? So it's first off, even enforceability is also discussed. First off, that discussion comes to the aid of the learned AGA in contending that the violation of terms of the policy per se would not give a coherent cause of action for ventilating the grievance before the courts. First, next paragraph. This next A is over. Go to B. B. The second submission of learned counsel for the petitioners that the school which has been chosen for the benefit under the policy at Annexure 1 has only the pupil strength of 226, whereas the school which petitioners are pointing out for the benefit, petitioners are intending to have the school, has 232 pupil strength, and therefore the norm in paragraph 4.4 in the subject policy is violated, is a bit difficult to countenance. First off, the policies of the kind are implemented on broad statistical data, in as much as the government is not working in the science laboratory to decide minuscule differences by applying the theoretical mathematics. First off. Next paragraph. In the above circumstances, this does not find any merits in the petition, more particularly when the grievance of the petitioner has been examined by the authorities within their discretion, and therefore the petition is dismissed. Having been made.
Let me say one small thing. I may be granted liberty because the collector has, yes, my lord, because the collector has not yet disposed the matter. The DO has submitted a report thereby suggesting the collector to set aside the grievance. There is no, the DO has submitted the.
In matters like this, nothing like that. Yes.
Only
Next.
to.
Item 4.
Program pension, similar your lordship posting on third week of September.
Issue notice. AGA to accept notice for the response. Any private respondent?
Private respondent, my lord, the last one is private respondent 4.
Emergency notice 2. OP number 4?
My lord. Yes.
OP number 4. Post along with WP number. Do you have
16,000 of 2017.
16,000 of 2017?
17.
Okay. Next.
Item 5. Passover.
Passover. What is that matter? Just say a few words.
I have not read out the file.
Why did you not read out? When we were
On behalf of Mr. Mishra, I am urging. I am.
you should, whenever you are holding something, some papers, you should turn the pages.
In another court, so that just ask me to take an Passover. Just 2 Passover.
Issue emergent notice. Who appears for the OPs? Put to hospital.
The university.
Issue emergent notice. Any standing counsel? In addition to taking usual steps, it is open to the petitioner to serve. Principal Government Women's College. You are there, na?
They have not served.
Learned AGA to accept notice for OP number 4 college. In addition to taking usual steps, it is open to the petitioner to serve a copy of the petition along with all the documents, stroke annexures to the panel counsel who ordinarily represents the university in question. Okay. Post immediately after service.
They can serve a copy to state.
Yes, give copy. Okay.
Item 6.
My lord.
Yes, sir.
The petitioner seeking direction from the Honorable Court to the
Penal action.
My lord.
Again, construction and operation of the building within a stipulated time period for upholding the basic constitutional rights. What is that? Basic constitutional rights are unknown. Basic human rights are known to the Universal Declaration of Human Rights 1948.
Yeah.
But we have not adopted that concept. We have adopted fundamental rights.
My lord, we are the purchasers.
Yes.
We are brutally cheated by the builder, my lord.
You are bitterly treated by the builder.
Builder. They are not followed any instruction, any bylaw which are required to construct a building. The builder started the building, my lord, in 2010. And almost 7 high-rising buildings, 280 units is sold, my lord. Not complying any documents, no compliance certificate, no building plan, no water treatment. Whatever the promises he made to us is not given.
You give representation to whom?
My lord, I have given application to all the government authorities.
Where are they?
There's a opposite parties number 1 to 8, my lord. And lastly, my lord, the builder taken a fake letter and the name of BDO, PPL, and handed over to us.
That letter or building?
Buildings completion certificate is taken from BDO, PPL, Block Development Officer, my lord. That is a fake paper, he handed over to us. So in that direction, my lord, notice may be issued to the opposite parties so that the brief facts would be come before the court, my lord.
All. Issue notice.
Obligement.
Who appears only for GFR?
1, 2, 3.
1, 2, 3. Emergency
1, 2,
notice.
3 and my lord, the 7 and 8.
1, 2, 3, 7 and 8.
Yes.
Emergency notice to the rest. Yes.
Item 7.
Petitioner has pledged to grant revised recently, my lord, similar or previously passed.
You have rectified everything?
Yes, yes.
Take that. Nothing. Just go on. Yeah, next.
Item 8.
8, my lord. Petitioner is working a lady matron, my lord, contractual basis. Now she is claiming for regulation after completion of 6 years, my lord.
6 years?
Yes, my lord. Your lordship and the government notification 12/11/2013.
It provides for regulation after
6 years, my lord.
6 years.
Yes, my lord.
Any matters we have issued notice?
Yes, my lord. Already similar matter, your lordship already disposed of, my lord.
They have not filed any representation, madam.
Your lord, similar matter, your lordship is disposed of, my lord.
You filed representation, you have filed.
Fresh
you have not
representation,
filed.
your lordship already passed fresh representation to dispose of, my lord, within a period of 3 months, my lord.
Provided there is a representation.
No, fresh representation filed, my lord.
Best representation, you will file that. Show that order copy to brother also. This photo. All these matters same.
Same, my lord.
Yes, sir.
Have you rectified?
No, same NS4 खाली 4 or 3 same matter, my lord. That same matter, my lord.
That order.
NS4 ଆଉ date of ଆପଣ joining, my lord.
Next, sir, I will.
NS4 3 or NS4 4, my lord. Pair NS4 3 or NS4 same date को joining का separate.
Written on separate. The subject matter of these writ petitions is substantially similar to the one treated by this court in WP 23122 of 2025 between Meena Kumari Pradhan versus State of Orissa and other, disposed of wide order dated 22/8/2025. First, the operative portion of the order reads as next paragraph. Learned counsel for the petitioner seeks identical relief at the hands of this court, and arguing that the principle of parity being the rule of administration of justice, his clients also should be treated on par with the litigants in the cognate case. First, per contra, learned LGA appearing for the OPs resists the petition, saying that in the absence of demand and rejection of a particular duty, public duties, ordinarily writ petitions are not entertained. First off, however, he agrees with the proposition of this court that if petitioner gives a representation, then the same should be treated in accordance with law and within a reasonable time. First off, this is appreciable. Next one. In the above circumstances, this same. In the above circumstances and with the same conditions as are stipulated in the order in the cognate cases, petition is disposed of.
Item 9.
May I please, Your Lordship? Here the prayer of the present petition is that for grant of modified assured career progression scheme, my lord, on completion of 10 years service from the date of receiving minimum granting age, my lord. But initially, as per the 2017 policy of the government, wherein the revised scale of pay was extended to the employees of aided educational institutions, therein, my lord, there was a condition for counting the 10-year service for MSCP that from the date of getting full granting age was to be taken into consideration. But in view of that, then I was not eligible. But what happened, my lord, in 2024, they have modified the policy by an amendment and said that it will be counted from the date of getting initial granting age. So in view of the 2024 modified policy, my lord, I am entitled to get the first MSCP
for which I was not entitled.
But you have given a representation.
My lords, I have given a
Let them
representation.
consider the
My
representation.
lords, in similar cases also, my lords have passed orders, my lords.
We have one order. You have changed the date and other things.
I'll change.
Just change them.
I'll change them.
Give it back. You consider the representation and pass order.
My lords. The connected matter is, my lord, similar, my lord. The connected matter is also similar.
Both are same.
Similar.
In both these writ petitions, the grievance of the petitioners is as to non-consideration of their representations, wherein they have requested to extend the benefit of first financial upgradation under MACP, taking into consideration the resolution dated 22/12/2017 and 16/3/2024 issued by the Government Department in Higher Education, Odisha, and thereby refix their pay in the admissible pay scale and to disperse the differential amounts in their favor as a consequence of such refixation. First up. Next paragraph. Learned counsel appearing for the petitioners submits that in similar matters, this court has already directed consideration of representations of the kind, and therefore, on the principle of parity, the same order be made in these two writ petitions. First off. Next paragraph. Learned counsel appearing for AGA on request appearing for the AGA, although initially resisted the petition on some technical grounds, now graciously agrees to instruct his jurisdictional OPs to look into the grievance of the petitioners as has been aired in the subject representations. This is appreciable. Next paragraph. In the above circumstances, petitions are disposed of. Time for consideration of the subject representation is 3 months, which would include communication of the result of such consideration to the petitioners individually in writing. First off, all contentions of the parties are kept open. First off, now no costs. Now no cost means in the second round, if I found defect in the order, cost will be personally payable.
Well, I've given the corrected copies, my lords. I've given the.
Not necessarily. I have given separate dictation. Okay.
Item 10.
But item 10 is that, my lord, for antedating of the career advancement, my lord, in view of the division bench judgment of the Hon'Ble Court, in similar cases, my lords have also passed orders, my lords.
Have you changed the date and other?
I'll change, my lord.
Yes. Give change the dates and other.
Yes.
Give copy to brother also.
Both the matters are same, my lord.
Yeah. Is followed up. Terms of WP number
23441, my lord.
223.
The previous WPC number. That is
give that because that order he has to hold. Otherwise, he may print some other order.
21172 of 2025.
Okay. In terms of that, just look into and drop it.
Item 11.
Brother Lenka.
Yes, sir.
I am basically against granting direction for consideration, but I am following the tradition of this court with some modification. When court directs consideration, and if ritualistic consideration is done, then the authorities will be in difficulty in this court hall. That you should warn your authorities. It is not for just having number of case disposal. I am not in competition for not showing my number of cases, etc. I have taken oath to do justice, not to give the number. Therefore, in appropriate cases, I may impose very heavy costs and inflict a very bleeding injury on the officials by my order. You should warn them. Consideration means due consideration, not something considered and rejected. Because 3 cases I have seen within 1 week. One lady is made to come before the court thrice. She fought the battle for 11.5 years. Then we make that order. What should happen? 11 years of battle in the court hall. Battle of Plassey. Yes.
Yes, my lord, the matter is covered with 20875, which is a transfer matter of primary school.
Transfer matter of primary school.
Yes, madam.
You have given the representation.
I have not filed the representation here.
You have not given the representation. What we have done in that matter? Let me see. Yes, sir. Covered by similar matters we have.
Yes.
Yes, he appears for the respondent there. Notice is for interim orders have been granted in several such matters. One being WPC 20894 of 2025. Therefore, similar interim relief has been accorded to the petitioner. First of all, this matter along with the state of the Yes, Mr. Russ.
Yes, one second. Lord, I'm just getting my note here in the fact. Before coming to court, we usually take down.
That's good also.
Yes,
that's good. G. Ramaswamy used to have a note of palm size.
Exactly.
It's palm size note. Everything in that. The notes are not that way. They are only indicative of
bullet points.
Bullet points, so that from memory it will arise.
Yes.
That way.
Well, this is how I prepare it.
Well.
But at the outset, I must say that I'm sweeping against the swim. The reason being, I'm challenging a suspension order. Scope of suspension and in the scope of challenge of a suspension order settled as back as in 1994, 2 SCC page 126 by Justice Ramaswamy.
1953 Supreme Court.
But before that. But I am up to 1994 Supreme Court. Lord Bimal Kumar Mahant, State of Odisha versus Bimal Kumar Mahant. Lord.
Yeah.
That's a judgment by Justice K. Ramaswamy as his lordship was then in the Supreme Court. Lord, scope says, Lord, the authority, appointing authority having power to appoint an employee has the power of suspending. Now, before passing an order of suspension, gravity of allegations and the requirement of keeping the employee out of the office is to be first considered. But that is the scope of challenge of the suspension order. Now, I am challenging the suspension order precisely on two grounds, my lord. One, the order is completely without jurisdiction. I'll be relying upon Hassan Abbas. Then two, the order in the teeth of judgment passed by this honorable court, where this honorable court had set aside the earlier order and entire matter was set aside. They should first comply with the order, reinstate me back. Now, after the judgment, having suffered the judgment, allowed the judgment to attain finality, immediately next, they have again suspended me with the same set of charges without complying with the order.
What are the grounds? First ground is?
First ground is it is without jurisdiction.
Without jurisdiction or without jurisdictional facts?
Without jurisdiction.
Without competence?
Without competence on the subject matter.
Who
kindly see
is no competence. Second one is?
But it's validity of directions given by this honorable court. In the teeth of directions given by this honorable court.
Number two. Number three?
These are the two.
These are the
because suspension, I can't take your lordship to facts.
Show that. Who is the authority?
Right, according to the petition.
Under which rule?
Correct. It is around 91 rules that Odisha Education Rules 1991.
Odisha
Education
91.
Odisha Education Establishment Recognition and Management of Private Colleges Rules 1990.
Your page and our page match? They do not.
Can I hand over my book to your lordship? I have read it, your lordship can see this.
Okay, you can read just.
I am reading it. So grateful to my lordship. Powers and functions of the governing body. Subject to the provisions of this Act, these rules, the governing body shall exercise powers and discharge the functions as follows, namely, your lordship must keep A to D, E to ensure proper implementation of the provisions of the Act, these rules, instructions issued by the department or director in the matter regulating conditions of service of staff, including their appointment, salary, leave, pension, provident fund, age of retirement, and disciplinary action.
Yeah.
It is on the governing body.
Any approval from the authority, etc.
That ratification is not there. Once it is ratified, it has to be treated to be a valid order.
Who has taken the?
It is by the president, not by the governing body. Number one.
Which is the constitution of the governing body?
Governing body they have constituted.
Show that.
Yes, it's there.
What are the powers of the president? Whether president acts on the
also the government
on behalf of the governing body.
Page 113, my lord.
113.
Yes, of my brief, my lord. Annexure 18.
This is governing body.
This is governing.
What are the powers and functions?
Powers of the function, I have read that, my lord. Is with the governing body to take action on the displayed matters.
No, what are the powers and functions of
this is here only.
Governor?
In the rules.
The president.
President's power. President of the governing body, the president shall ensure that decisions taken in the governing body are implemented by the secretary and the governing body functions properly and hold its meeting regularly. In case the secretary defaults in calling a meeting of the governing body as directed by the president, president shall have power to make such arrangements as he deems appropriate so that the meeting can take place. So,
here's residuary power.
But one more aspect. If you could see the suspension order itself, they have referred to a particular rule there. Page 18. Yes, this is the bylaw of the institution. That the society, it has its own bylaw. As per this bylaw, even this rules, it is the secretary of the society, he has the disciplinary power action, not the president.
No, but president has supervisory power on the secretary also.
Unless he supervises or ratifies. But this order is not passed by the secretary.
Need not.
That your lordship will appreciate. My second point, on the question of jurisdiction, I have Hassam Abbas with me, I can cite.
Yes.
And old judgment, 54 Supreme Court 340, an order without jurisdiction is a nullity.
That was a court order.
Court's order.
That is Kiran Singh versus
Kiran
past one.
So grateful. But that's the judgment. But lordship, I know your lordship. But the court or tribunal probably is also there. Or the
courts have differentiated.
That's fine. That's fine. But the principle is when it is without subject jurisdiction is on the question of subject matter, it's a nullity. That is what also Hassam Abbas says in 2007 Supreme Court.
That VV is overruled in 1992 SC.
I am saying of 2007.
2007.
Right.
How many judges?
That's.
But judgment which I am saying is of 3 judges.
This is 2 judges.
Now, because of plurality of the cases in the apex court, many judgments are not brought to the
notice of the court. No? But then this is the broad principle I am saying to your lordship, not for your lordship to appreciate and consider. Not my
that the idea that an order without jurisdiction is a nullity is treated by Wade, Professor H.W.R. Wade and Farsit in his administrative law. It is not as simple as that.
Not as simple.
It is not like Mohri Bibi versus Dharmodas Ghosh. A contract of a minor is ab initio void. That ab initio void concept is not adopted in administrative law.
Yes.
Somebody should challenge.
Yes.
Somebody should set it aside.
Yes.
They call it as magistra dicta, the order of authority. To say that it is without authority is a side point.
Correct. So
very beautifully they have discussed. Do we have that 1992 Supreme Court where they have referred to?
I'll definitely read and go
through from Google.
But I'll take it down immediately.
Just read that paragraph. Many students are sitting there.
I'll definitely go through that.
Performance of great lawyers. But Wade, they quote Wade at the para perhaps 6. And the paragraph begins as, apropos to this principle which Wade discusses. And Wade refers to an English judge. I forgot his name. Nowadays, memory is playing trick with me.
We are also of the same stuff. We are also, of course, we are also suffering. I may be 1 year junior to your lordship. We are also suffering the same difficulties, my lord, sometimes.
Bhagavad Gita, there is a shloka, very often I tell it to myself. Smriti Bhramshat Buddhinashat Pranashat. If our memory power depletes, then the fall begins. How beautifully Bhagavanta has said that. Lord Krishna, you are Jagannath.
Hats off to your lordship, my lord.
Just read that paragraph. Many students are here.
That 92 Supreme Court or 2000?
92. Yes.
92, I'll have to get that judgment.
Can't you get it from your students of
Let him get it. I'm getting it in a while, you know. 92 Supreme Court paragraph.
State of Punjab versus from Jagjit Singh or something like that. There are 5 or 6 very beautifully written judgment. Correct position of law, which they have quoted.
But keeping that in abeyance for a moment, can we proceed further so that in the meantime they'll get it and we'll...
Yeah. We don't have a Supreme Court judge.
Your lordship's research assistant can get it immediately.
But unfortunately, I don't have one.
But
I think I have to do. I am yet to get research assistants. My request is pending. I don't know when I have to file the writ of mandamus. Yeah.
To the registry one.
Okay.
Lord, my next point is, Lord, keeping the, I'll definitely come back to it. Lord, earlier, initially there is 2 concepts. One is educational agency, other is a governing body. The educational agency establishes the institution. Till the governing body is formed, the educational agency manages the institution. That is the law. Under Section 7, governing body is formed of the Act.
Of Education Act.
Education Act. Now, educational agency, before formation of governing body, on identical set of charges and allegation relating to incidents of 2016-17, placed the petition under suspension. And that was challenged before this.
What is he?
He is at present a principal in charge, appointed in 1990, continuing till date, till he is interdicted by suspension. And what is the allegation? 16-17, there was some purchase of books wherein he accepted a quotation. 16-17, he accepted a quotation without consulting the department.
What was the amount in what?
Amount. That's not there in the charge. That's not there in the charge. Kindly see page 21. It's only about 19%, 25% discount. 16-17, he accepted some quotation. 2025, you are taking cognizance and initiating proceedings against the petitioner, and he is due to retire next year. He is 59, next year he is going to retire.
Because they said we'll give you discount of 19%.
That is the allegation made 16-17, and we are in 25. As your Lord, if your lordship will consider it in the prospect of malafide. You slept over for 10 years. Suddenly you woke up from your slumber and...
Is there any audit objection?
No objection, nothing. Kindly see the list of documents. The audit aspect is not there.
But there is another aspect of manipulating the record.
Manipulating my leave application. From 3 days, they say I have made it 4 days. But that's subject to me. That's only my leave application was for 3 days. They said you have made it 4 days. How can I, once I submit my application, how someone will again make it 4 days? Matter of 1 day.
Who appears for the
notice has to go.
As a cabinet
As a cabinet is there, sir. I'm sorry.
appearing for
opposite party number 3 and 5. I have the instructions to appear opposite party number 4. Since I have not got the Wakalatnama, I am not able to find. But my humble submission is that earlier the charge sheet was filed, it was set aside by this Hon'Ble Court by Honorable Single Judge, and it was challenged in writ appeal. Writ appeal, your lordship may kindly turn to page number.
Writ appeal, what happened? You can tell that. I believe you.
Only writ appeal, only one paragraph I will show you.
No, you tell that. I will remember.
Only one part was set aside, and the remaining part of the observation made by the Honorable First Single Bench remained intact manner.
What is that part?
That part is.
So the suspension continued?
No.
It was set aside.
It was set aside because it was of the jurisdictional error. When the governing body was not there, the entire proceeding was initiated by the Educational Society, and Honorable Single Judge was pleased to hold that the entire proceeding initiated by the authority had no jurisdiction to initiate. That is why the suspension, order of suspension and the charge sheet was set aside. It was under challenge before Honorable.
Need not name the judge.
I beg your permission.
Should not name the judge. Should not name the lawyer who argued. Man should say so and so argued.
The Honorable Single Judge has held that, therefore, this court is of the view that petitioner will be allowed to continue his original post of lecturer in commerce so appointed by order dated 37/1990 under Annex 4 series till the college gets a governing body duly approved by the competent authority. The governing body so constituted and approved will take a decision and with regard to the claim of the petitioner to get the benefit of promotion, if any. The petitioner challenged this finding
in writ
appeal, and the writ appeal was disposed of this observation that accordingly the portion of the order of which the appellant has been reverted to the post of lecturer is hereby set aside. That part only was set aside. The remaining portion of the order is unaltered. It has been brought to a notice in course of hearing that the governing body has already been constituted and have taken charge of the college. Thereafter, it is open to the governing body to take action as permissible in law.
Correct. No, justification. We'll assume that you have power now. Why after this is of 2016-17? How suspension would facilitate holding inquiry? You can hold inquiry. But why to put him outside? We are having only 1 year of service.
My humble submission would be, your lordship may kindly turn to Annexure 1 and 2, which is under challenge in this petition. Yeah. Page number 20. Annexure 2, page number 20. Annexure 2 starts with page number 19. The very next page, that is Annexure 20. Page 20.
You are hereby called upon.
You are hereby called upon to submit the explanation in writing on the above mentioned charges leveled against you. Your explanation should reach the undersigned within 7 days from the date of receipt of the charge sheet, failing which it will be presumed that you have no explanation to offer so and so, your lordship. My humble submission would be that when the petitioner is called on to file so cause, this writ petition itself, my humble submission subject to your lordship's acceptance, would be that it is premature in nature. He should have.
No, he is against suspension, not against this. He will give explanation. That's another.
Your lordship may kindly see the prayer they have made.
I don't see. We do not. We are not English courts. It's not a king's bench. This is more like a Mufuzil court, in my opinion. With due respect to everybody, more like a Mufuzil court of High Court. Okay, we cannot. Apex Court said, while reading the pleadings of the parties, we cannot keep our common sense in cold storage. I'm only reproducing the words of the Apex Court. All right, I'm not doing anything else. Now, I am asking you, 2016-17, the book scam. We'll assume that it is a scam.
Yes.
Okay. You are giving 7 days notice.
Yes.
And you are threatening him. If you do not reply, then it is deemed that you have no defense at all. Are you launching satellite?
In that
16-17.
In 2020, it was initiated. That was
Fortunately, you did not say what all happened during Babur came to this country, you should give explanation within 7 days. What is that?
But yes, he has sought for extension of time because of his ill health.
Therefore, you will give that is another case. Where is the requirement of keeping under suspension principle? You hold inquiry. You hold inquiry. I know the limitations, court's limitation in treating suspension matters. Is it? That appears to be sensible. Instead of staying this and allowing him to retire with stay itself, then after retirement, everything being reopened. Instead of that, hold inquiry. This is not after all an inquiry into 302. What happened? Whether books were bought, commission was pocketed. Okay, we do not know. About 9-8 years have elapsed now. Number one. Where is the requirement of suspension? No. It should be fair. The institution should be fair. At the same time, we will put him under condition that he will not manipulate records. He shall fully cooperate in the inquiry. That way we will do that. Are you agreeable with this proposal?
I agree to your lordship's.
Of course, you have argued very well. That's another thing. But where is the suspension should not be resorted for fall of the hat. Generally, the principal is the conscience keeper of the institution. He is the conscience keeper of the institution. Some lapses happen. Even Shakespeare says, an honest honey sucker licks his fingers. I'm not casting any aspersion on anybody. An honest, this is what Shakespeare has said. An honest honeysucker, after taking the honey and handing it over to the master, taking his wages, he will not just wash his hands, he will lick his fingers. That nature is with man is all right. That should not happen. That's another thing, because he is principal, many students will be there. They will be looking at the principal for his behavior, conduct, character. So many things. That's true. But where is the case for suspension? No case for assuming that you have power to suspend. Power, existence of power is one thing. Exercise of power is another. In colonial days, existence is the ground for exercise. But we are in a welfare state. The employer has to conduct himself very honorably, respectfully, talk with the employees. So we will stay that now and let him cooperate in the disciplinary proceeding. And then we shall do that. That we will pass the order after Mr. Ratho reads that word.
But I got that judgment. I am so grateful. Year 91 Supreme Court 2219.
Correct.
The state of Punjab versus Gurdeep Singh.
Correct. Read para 6.
Para 6.
There the contention was, the order of dismissal is without jurisdiction, therefore I can avoid on my own. I cannot go to any court.
Approach to this principle, Professor Wade states, the principle must be equally true and where but brand of invalidity is plainly visible. For there also, the order can effectively be registered in law only by obtaining the decision of the court. Professor Wade sums up these principles. I'll give a printout on that also.
Even if invalidity is apparent on the forehead, somebody should
1996 Supreme Court page 906. That says invalidity is not written on the forehead of an order. It has invalid or void order is binding inter partes, still it is set aside by a competent court of law.
That is what?
Year 96 Supreme Court page 906.
No, that itself is the
yes.
Maybe it is printed.
Right, and reiterated the same view in several other judgments.
But heard learned senior advocate Mr. Ratho appearing for the petitioner and learned suing for panel counsel Shri so and so appearing for the OP numbers
3 and 5.
3 and 5. Who are the answering respondents? Mr. Ratho submits that the impugned order is liable to be stayed on two grounds, namely the competence of the OP who has issued it, since he lacks it. And number two, there is a violation of the earlier order of this court in WP number.
WP number
17316 of 2020.
176 of 2020 is forwarded upon
24th of January 24.
24 1 2020 instead of 3. And the subject matter of inquiry being as old as 8 years, and also the allegations being not that severe. First one. Next point. Learned panel counsel opposes the issuance of any interim relief, vehemently contending that ordinarily power to suspend is the kindly be seated in the prerogative of the employer stroke competent authority. Semicolon. Suspension is not by way of punishment, but is in contemplation of inquiry. Vasanto. 7. Thirdly, suspension is not stigmatic. It is only facilitative of the intended inquiry. Lastly, no prejudice should be caused to the employee, since he would be drawing the subsistence allowance, and his status as principal is also not affected. First one. Next one. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant the reprieve of staying the suspension order for the following features. A. Petitioner is not in the lower rung of the service. 7. There is no track record of any delinquency earlier. He having been in service since 1990. 7. He is going to lay down the office on attaining the age of superannuation shortly. First, ordinarily, an employee having unblemished long service record is viewed with due respect and credibility. First. Next paragraph. Mr. Ratho is right in drawing attention of the court that regardless of in submitting to the court, regardless of the competence to issue the suspension order, the case does not merit any such action. he has placed reliance on the order of the coordinate bench earlier. First one. Power to suspend, although is in the nature of a prerogative, comma, it is subject to judicial scrutiny, comma, howsoever restrictive the scope of such scrutiny be. First one. Suffice it to say that suspension should not be resorted for the fall of a hat. Next. See. It is not that in inquiries, contemplated inquiries of the kind, comma, the proceedings would be affected if suspension is not directed. First, petitioner, through his counsel, undertakes to fully cooperate in the contemplated inquiry. First, the totality of facts and circumstances give an impression to the court that the suspension is even otherwise not warranted. First, in the above circumstances, include the order is stayed with the above conditions. Okay. Great one.
Item 13. Item 13.
My lord, on that Mr. Das, my lord, and taken by next week, my lord.
3 weeks. At the request of.
Item 14.
Lady candidate, the petitioner was in a recruitment test mirror. She is selected for the post of postgraduate teacher conducted by the OPSC. In the merit list, my
teacher,
postgraduate teacher,
PG teacher,
to be appointed in junior colleges, higher secondary schools. And my select list at page 18, my position out of 50 candidates, my position 24th. On merit, my lord. In order of my position, I'm a social and educational backward candidate, my lord. Woman, ACBC candidate. By virtue of my higher mark, I was selected against unreserved woman candidate. There is a on 16/8/25, my lord, there is a counseling for choice of posting in order of merit, my lord.
Yes.
Choice. That counseling is required as per the resolution Annex 2.
That counseling to be set aside now.
No, my lord.
You have sought for that prayer.
My counseling has to be because they have not followed the resolution. My position is 24 on merit, my lord. I was not called to counseling, my lord. My juniors at serial number 20 placed on the merit, placed on the 25, 26, 27, 28, 29. Yeah. We are given first preference, my lord. But I was, my position was down to 49 position.
From 24 to 49.
49, my lord. They have choose better position. Because I was selected in this unreserved woman post, my lord. And LRC said the one candidate, my lord, serial number 29. A lady, woman candidate, SCBC woman, she was selected against the SCBC candidate because I was for higher mark, I was selected as an unreserved candidate. I was not
pushed to general merit.
Yes.
Because of higher merit.
Yes.
By that, you should not be prejudiced, is your case.
That should not. There is a guideline, my lord, of the government of India. I have given at page 12, an SCSC candidate appointed on their own merit by direct recruitment or promotion
and adjusted against unreserved points will retain their status as SC/ST and will be eligible to get benefit of reservation. That reservation.
92 Supreme Court.
Yes.
That Indra Sahani.
Indra Sahani.
Indra Sahani. Yes, so you accept notice to that.
No, commissioner has not made any part.
Commissioner is not made a party.
Commission may make. Not necessary, my lord.
Necessary. Who has made this impugned order?
Director, my lord.
Director.
Yes, ma'am.
Now,
Looking about
Vote number 2. Any interim order you have sought for?
my lord, if you have-
That is sought for.
No, my lord.
Issue emergent notice.
My appointment, they will give appointment, my lord. Then my right to choice will be lost, my lord.
But where is the interim prayer?
Indian prayer made, my lord.
You have sought for?
Yes, ma'am. In
What is that interim prayer you have made?
IA number 14416.
For? What is the direction you have sought for?
No appointment shall be made postgraduate teacher.
No, all appointments will be asked.
Actually, I am giving to 3 choices, my lord. 3 choices, my lord. I am giving to. These are 2.
You cannot, interim order should not ransack the recruitment.
Against the 3 posts, my lord. 3 choices I am giving, my lord. 3 choices, ma'am.
Learned counsel for the petitioner submits that that his client was at serial number 24 in the select list.
Select list, madam.
Select list. And that now he has been down pushed to serial number 49, comma, treating him as unreserved candidate.
Yes.
When he answers the description of reserved category, semicolon, he further submits that merely because a reserved candidate scores more than general merit candidate, comma, his status and privilege as such cannot be robbed away. In view of the government notification of central government notification, we read that.
That and page 14 of the page 12, my lord.
Annexure?
Annexure 3, page 12.
Annexure in central government notification.
Annexure 3, page 12.
Dated what?
2020.
11/7/2002.
11/7/2002.
Clause
At Annexure 3.
Clause 3, last clause, my lord. SC/ST candidate.
Annexure 3. First stop. A prima facie case is made out for issuance of emergent notice and grant of interim relief suiting to the circumstance. First, next paragraph. In the above circumstances, issue notice. First off, ASC for
1 and 2.
1 and 2.
Others are private response.
Emergent notice to private respondent, OPs.
3 to 8 minutes. Private response.
Yeah.
3 to 8.
During the pendency of the petition. What is that? Petition. One post in the following institutions shall be kept vacant. Take this. One post in all the following institutions shall be kept open, kept unfilled. Unfilled. Okay.
Number 15?
Yes.
Well, this is a case of transfer.
One second. Rest of the posts can be. Yes, yes. Yes, sir.
Well, this is a case of transfer at the instance of the local MLA. My lord has passed similar order.
Give that. Sure. So entire transfer is stopped now. So now what should do? Because you are bringing MLAs, MPs, if they are going to dictate terms to the colleges and institutions. How? How then the quality of institutions will be lost?
Your lordship,
We'll hear all these matters.
yes,
They will
matter.
fix that.
Yes.
You have seen, in fact, in England, the English Parliament recommended grant of doctorate to Margaret Thatcher. The university has simply put that resolution into the dustbin, saying that it is university who will decide to whom the doctorate should be granted, not you people. Interference in everything is too much. Where will be the quality? Tomorrow all teachers will be, and the teachers are hired for the census, for updating of voters list.
Yes.
Suppose tomorrow, if they whisper to the family members, you vote for this party, this candidate, that is the purity of the election itself, apart from other things. Issue emergency is and interim order.
Well, I have given the corrected copy also.
Disposal only?
No, not disposal.
Interim order as in. Sorry.
Your Lordship may clarify one thing. The petitioner may be allowed to continue in his previous post.
Person. The petitioners shall be continued in the previous institution wherein they were working before the issuance of the transfer order.
Yes. All cases are same, similar.
All these cases similar?
Yes.
Just look into. All this matter along with WP?
That is WP. When WPC number 20875 of 2025.
20875
of 2025.
Any date is fixed?
Second week.
Second week of September.
Second week of September.
We'll finalize that once for all.
Yes.
Next.
Item 16.
May I please, my lords. Here, my lords, small children and their guardians before your lordships prevented from continuing the schools for the studies, my lord. Act like this, my lord. One public school was run in campus of the ITBP here at Khurda, where the present students are admitted and continuing their studies. But in the current year, that school has been upgraded to the KBI, Kendriya Vidyalaya. And now, minusing the present students, they are admitting all students as per their rules. And neither they give it TC or transport certificates to go away from this end of the session. And in the middle of the sessions, they are allowing to continue. This is the whole pity of the present small children.
Who appears for the
My lords, I am acting for the 1, 2, 3, my lords.
1 and 3?
Yes. Today morning received the copy.
Issue notice. Learned panel council appears for OP numbers 1 and 3 and he has filed power. When shall we call this? And others, AS, AGA?
No, my
No,
lord.
central government.
1 to 3.
My lord, 4 is a public school, my lords.
For the school, my lord. The school notice is to go.
Kendriya Vidyalaya, they have
This panel council. Issue emergent to OP for school.
Speed post.
By speed post. Post immediately.
Yes, today I will post it.
No, posting this matter immediately after service.
Yes. What
is that interim?
Because they will complete their admission, then the present students will have no seats because seat limits are 40 only upon each class. And these are the students continuing in the school, millets.
How many students there are?
Now 114 students, and some students have 10 to 14 students have got their seats as per lottery, but the others are not getting. Those persons have come for seats, they are not getting bloods.
No, but they are not parties now. How can I prevent admission of those parties?
I am not. I am kept reserved for the seats for the present students. May be kept reserved.
My lord, I am instructions by the present status of this, my lords. Next date, my lords, and pass an order.
So by that time you complete the admission and the admission has become infructuous that way. Copy is served on you when?
Yesterday.
Yesterday.
Received
Put a asset and the admission process. Now telephone and come back. You can call from here also. I permit you to call them. Call to your
next
phone.
week, next week.
No, in the meanwhile, if seats are filled up, what should happen? Then children will be crying. They will curse the judge. Because they say our lawyer has argued very well, but judge did not understand anything. Yes. You go and speak to the when admission process is being completed, how many seats are now available? But they should speak the truth. Otherwise, I will direct the police superintendent to go and seize all documents. Because they should not show that they have filled up today itself. Speak and call this matter at within 3 minutes. I will call it. And I'll return within 3 minutes. With your kind leave, I am going and come back. Ranjit has to come. Even if Cobra comes, I cannot go. Yeah. 16. 16? Now, what is this matter?
My lord, 16. They have gone to take instruction.
Yes. That advocate for the petitioner also changed him to overhear what he will be speaking. Yeah.
Item 17. Kindly give some time for filing counter.
May I plead my IA? I am facing one IA, Lordship. I have filed.
What is that?
That is IA number 13077 of 2025. I am for the counsel of the petitioner, Lordship.
For what?
Order dated 30/7/2025. This one will go directed to solve the pleading on the counsel for the opposite party, Lordship. And we have already solved all the counsel for the opposite party except the opposite party number 5, Lordship. In our bar, we inquired that there is no such existing counsel for representing opposite party number 5, Lordship.
So
therefore, I pray, Lordship, I take notice, Lordship.
Notice.
Yes, Lordship.
That is IA.
Yes, sir.
So you could have moved a memo.
No, I inquired in the registry, they directed me to file an
IA for everything. But first decade memo would have been sufficient. In terms of application number 13077/2025, supported by affidavit. Issue emergent notice to OB number 5. OB number 5. Item 18 by registered post.
Speed post, Lordship. Registered post is no more.
That's right. Yes.
Item 18.
May I please, madam?
My lords.
Matter relating to my lord, miscommunication matter, my lord. That matter, my lord. I draw your attention, my lord.
Excommunication.
Sorry. Excommunication.
My lords.
Excommunicating is being miscommunicated.
I draw your attention, my lord.
My lords, I am filing affidavit by the police that amicably they have settled the issue. And it is over.
I am for the opposite parties.
This order when they did something.
As per lordship direction, my lord, have the action never taken, my lord?
They have done that. So why is police lie with the affidavit? You can haul them up for perjury.
Again. My lord, there is a copy on much of this affidavit, lordship.
Yeah.
I don't know, my lord, what happened, my lord, that would
Petitioner has a statement there as under. First off, after service of notice, OPC representing the learned ATA have filed a long affidavit.
Para 9, your lordship kindly refer to.
8/25/2025. Sold to by Deputy Superintendent of Police, Mr. Vivekananda Swain. Which paragraph?
Para 9, Your Lordship.
Learned AGA, drawing attention of the court to para 9 of the affidavit, submits that all corrective actions having been taken with the participation of major section of the village leaders, the issue has been very amicably settled, and therefore the petition be accordingly disposed of as having become infructuous. First of all. Next paragraph 8 and 9 read as under. In the above circumstances, petition is this.
May I add one thing, Your Lordship? I am for the private opposite parties, Your Lordship, except for opposite party number 7, Your Lordship. I have agree with the affidavit filed by my learned senior. And I being one of the accused person in the FIR, I have no animosity with the petition. That may be also.
Yes, sir.
So, but the affair is
But he himself is telling the court, I have no animosity against.
They are delete from affair. The affair stories are a different story, my lord.
No way, whatever you want to do, he said. Para 9 reads as that. First, learned counsel appearing for OP number
5, 6, and 8.
5, 6, and 8 submits that his claims are agreeable with the police version.
With the compromise, the annexure which has been provided.
This is version of the police version. And that they do not have any animosity for the petitioners. His submission we have noted. We have not said right or wrong.
Yes, grateful.
Why this village brothers should not be villages should not be in turmoil.
Fabric of the society.
But excommunication is yet.
No, that is it's not the actual story. But I don't want to go in the merits of the case. Now it has been compromised. Yes, grateful.
Pass over at 16, my lord.
16. Yes, brother.
My lords, I mean wrongly mentioned. I am appealing for only OP1, my lords. 2 and 3, the Kendra with the other separate panel councils.
OP1 issue notice. You are CGC.
Senior panel council.
Senior panel council Shri so appears for OP number 1. And has filed the power. Issue emergent notice to OP numbers 2 and 3. 2, 3 or 4. 2, 3 and 4 by speed post. Next paragraph. Learned counsel for the petitioners expresses apprehension that unless the admission process is interdicted, his claims would be put to prejudice. First off, there is some force in this submission. Next paragraph. In the above circumstances, the admission process shall not exhaust all the seats available in the institution But keep how many seats?
Minimum 25. Before your lordship, 25 students are there.
Petitioners keep 25 seats unfilled. Unfilled. Comma.
In respect of
Unfilled. That may inure to the benefit of petitioners should they succeed in this legal battle. First one. Comma, till next date of hearing. Call this matter immediately after. All right. Go to the next. Item 19.
Ordered at the 20th of this month, my lord, a trend was directed to take instruction on the issue, my lord. My lord, here the challenge is to the annexure 14, the inquiry report itself.
Objections filed.
Well, it's no, we have not received. Only in 25th, 2 days back, we have sent the letter. And the noting is that requisites for issuance of notice to opposite party number 6 is not filed.
No, it appears he has applied now.
Already filed, matter. It filed since 22nd of August.
Requisites applied to be processed immediately. Okay.
It is there.
But I have said that. Now he has to file objection, na?
So far as the interim order is concerned, my lordship has kept it today. That is why, yes, my lord.
What is that interim?
My lord, your lordship have a glance at page 14. Sorry, page 55 to annexure 14. Well, I have asked to file the so goes reply to the annexure 14.
Yeah, reply.
Second so goes reply.
You file supply. You send the reply.
No, if I will send the reply, my lord, immediately they are talking that to me. But in fact, your lordship have glance annexure 11 first. Annexure 11 is the previous enquiry report. That enquiry report was submitted when this honorable court was pleased to stay that proceeding due to non-supply of documents. Thereafter, under annexure 12, that inspection was disposed of with the direction that your lordship will get at page 50. The relevant portion your lordship have a glance.
50.
Yes, 50. Having had counsel for the parties, considering submission and the fact that the petitioner have already been provided with the documents on 3/12/2024.
Yes.
Petitions are directed to file the written statement of defense on 7th February 2002. Option to that, the annexure 13 is my statement of defense.
Yeah.
Your lordship, the report is that no page 57. It is pertinent to submit the delinquent teacher Sri Singh had not submitted the statement of defense. I submitted the statement of defense. In fact, my lord, no inquiry has been conducted. Whatever inquiry report was submitted earlier.
What is the allegation?
The allegation that he submitted the fake certificate at the time of joining in service. He joined in service in 1996.
Fake certificate of what?
BD certificate. BD certificate.
You say that it is not fake.
It is not fake.
Genuine.
Yes. And inquiry it will come out. Well, last you have a glance. Annexure 11, the inquiry report. The same inquiry report without changing a single word or say even with the comma full stop is same. The very same report again has been supplied.
Saying that it is fake certificate.
Yes.
My lords, it is confirmed by the university. My lords, kindly see page 58, fourth para. During course of inquiry, delinquent as to
University said that.
Yes, my lord.
They said that they sent it to the university for verification, and the university has submitted the report that saying that
he failed, but he has given his
failed.
But you gave that you passed.
Passed.
Yes.
Then how can we protect you?
No, my lord. The inquiry arbitrarily, my lord, the basing on the report of the university.
What else is required? You know, the degrees are generated at the university level.
that the inquiry has been conducted, the proceeding has been initiated.
All right. Now the question is whether it is a fake certificate or not. University says he was shown to be failed in our exam.
No, that is the question, my lord.
What is
From which source, my lord, the university confirmed, gave the reply that is failed.
Yeah.
That I want to prove in the proceeding, my lord.
How?
I will prove, my lord, if that the authority will come, the author of that document, he should be cross-examined, put to cross-examine.
No, university says, no,
So
but
that
is for the grant of interim prayer, I'm telling you. In a petition, whatever may happen on merits is another thing.
Yes.
The person, if university says this person had failed, that should be taken with face value.
That is true, my lord. But here, my lord,
Cross-examination.
here, my lord, an inquiry proceeding has been initiated.
No, city in question, where from the petitioner graduated, that is BEd, comma, the certificate is not the tester, the petitioner was shown to be failed, whereas he got employment by producing a certificate which shows that he had passed. Personal. At this stage, no interim relief can be granted in matters like this. Next.
Item 20.
Application. Yes.
Also, let's say whatever action that will be guided by the.
That will be subject to outcome of the petition. It is made clear that whatever action that is going to follow at the hands of the disciplinary authority would be subject to outcome of this petition.
All the three cases.
Yeah?
All the three connected cases are
same matters. In fact, instead of me saying all these things that may influence the decision making at the hands of the authority, they will say, High Court itself has said like this. Instead of that, the best way is you file your representations, replies, you await decision making, then you come before this court. So that you can, otherwise this will remain, this is sufficient for you to put an end to your employment. That should not happen. Therefore, what I can do is, in all these matters, the petitioner, I'm just suggesting, I leave it to your wisdom, because you know the best interest of your client. What I am proposing is, we will dispose of these petitions, giving liberty to you to take up all contentions in your reply, representation, second Shukar reply, whatever.
Yes.
In the event you suffer an adverse order, that order shall not be given effect to for a period of 1 week. Yes. Okay? So that you can approach whichever authority you want.
Yes. That is the DO.
Suppose you are dismissed from service, they will not give effect to that order for one week.
Yes.
That will serve your purpose. Yes. Instead of that, this should be the lawyering in matters like this. Yes. Who appears for the OPs?
My lord, I am appearing.
You are appearing.
No, I am appearing.
You are appearing for OP.
1 to 5.
Yes. Now the suggestion is, in 2008, 7 SEC, if I am right, the Apex Court passed similar order. That was in relation to renewal of a lease for mining. The council said, if you dispose of this matter, very next day they will terminate my lease. Then court said, you take decision, but you don't give effect to that decision for a period of 2 weeks and dispose of the main matter. Therefore, what I am going to propose here is not a new thing. It is part of our jurisprudence. Can anybody get that? The mining lease 2008 Supreme Court, SEC.
142 power is the
52. Not 142. It is principles of natural justice. No, he is not coming in the way.
My lord.
It is better for you instead of keeping all these things.
My lord.
But
as your lordship, please.
Both the sides having argued the matter agreed with the proposal of this court that the ongoing disciplinary proceedings should not be interdicted and that the petitioner should be given opportunity to file his reply to the subject second show cause notice as well. Learned counsel for the petitioner submits that the OPs are hell-bent in putting an end to his employment with one or the other pretext, and therefore, if any adverse order is passed in the disciplinary inquiry, the same should not be given effect to for a period of 10 days. 10 days. First up, this proposal, learned AGA opposed, saying that it is not that desirable to do it. First up, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is of considered opinion that justice should not only be done, but should be seen to have been done. First up, there is no interdiction of the disciplinary proceeding against the petitioner in relation to the genuineness of PED certificate. First, let the proceedings culminate into an order, this side or that. First one. Next paragraph. However, if any adverse order is passed against the petitioner in the subject disciplinary inquiry, the same shall not be given effect to for a period of 1 week after it is served on him in writing. First, petitions dismissal.
Only liberty ballot I will file by because
liberty is reserved to petitioner to take appropriate action proceeding if any adverse order is made in the said inquiry. In that connection, all contentions are kept open. Okay. All right. Item 20.
My lord, no instruction in the matter. It was old matter.
1998 matter.
My lord.
What instruction? You are not cross-examining anybody.
No,
you are based upon the merits.
Merits, my lord. An internal road was proposed to be built by the development authorities.
You are arguing
on private lands.
No, you are arguing on merits.
No, I am not arguing. Since your lordship asked so the facts. So, but after so many years, my lord, no contact
what is
with
the prayer now?
Prayer was not to give effect, my lord, without not to take those private lands. It was supposed to be built on private lands. The development authorities planned an internal road in the city. Huh? So, the Barambur development.
Read the prayer. Read the prayer. Give that one copy.
Copy.
Yes, give.
What I was praying, my lord, your lordship may dispose of the matter with a leave to refile if cause of action survives. So that will my prayer.
No, that will do justice. Now, since 98.
My lord, 98 matter, so it should
what
not.
Your client will say about you, he will appreciate, but about the judge, he will feel bad.
Yes, right.
I have been waiting for 40 years, 30 years, and this judge has said disposed of with liberty. What kind of justice will be done?
I am reading the prayer, my lord.
Read.
At page 5 of the writ. In the circumstances,
writ of certiorari quashing the impugned order, Annexure 4.
Annexure 4.
Writ of prohibition prohibiting SP2 not to interfere in whatever manner on
whatsoever manner
operating under
private structure, my lord.
Where municipal holding. Are you owner of the property?
I am the owner of the property, my lord. The annexures, one is my RORs, my lord, and sale deeds. Annexure.
Yes, brother AG, what do you say?
The lords,
showing the ROR and the sale deeds.
My lords, this is Berhampur Development Authority.
Appearing for BDA, my lord.
Yes.
My lord, as it appears, the main learned friend challenged the impugned order under Annex 20. Correct. It is passed in exercise of power under Section 91 Orissa Development Authority.
91-2.
91-1. Section 91, subsection 1 of Orissa Development Authority Act 1982. Which confers power on the authority to initiate a proceeding, issue so cause, and after hearing the parties pass appropriate order directing removal or demolition of that unauthorized construction. Here, notice was issued under Section 3, under Annex 3 matter.
Notice was issued to him.
And he has filed the reply under Annex 6, saying that it was the ODA Act is not applicable. It was old construction. Well, that has been considered and passed a reading order, which is the available one under Section 91, subsection 2.
Available one.
Yes.
But at this length of time.
Well, I have not instruction at this juncture since it is a old matter. But it is the fact that.
But we will send him to the appellate authority, subject to the condition that we will not give effect to that order for a period of 1 month.
What happened in the meantime, I have no instruction.
Very well.
Yes.
Now,
Yes,
we
Your
will
Lord.
say,
Yes, Your Lord.
because you want to send him to the other hospital.
Yes, Your Lord.
In the meanwhile, you cannot pull down from the bicycle.
My lord, in the meantime, my lord.
We have to, if you are non-shooting on the ground of availability of alternative, he has to be protected.
My lord.
Okay. Perfect. Petitioners, how many petitioners? Only one petitioner.
Connected matters are there, my lord.
Where are they?
They are on board, item 20.
Item
1, 2,
item
3,
20, they're
4,
tagged up, my lord.
5, 6, 7, 8.
All these matters are
Identical, my lord.
OJC.
My lord, while widening of road, on verification, it is found some portions have encroached upon government road.
OJC means original jurisdiction.
Original jurisdiction.
Under 226.
Now,
Under
nomenclature as WPC.
Before under 226.
226, my lord.
Presently, nomenclature as WPC.
Then it was OJC, my lord. In 98, it was.
Those days it was OJC.
Those days it was OJC.
But in all these petitions, or challengeable, the coercive orders made by
Berhampur
Development Authority under Section 90, subsection 1 of Orissa Development Authorities Act 1982.
91, my lord. That is 91.
91, that's what. 91-1.
Yes.
Orissa Development Authorities Act 1992.
1980.
82. 1982. First one. Next paragraph. Learned counsel for the petitioner submits that the impugned orders have been passed without giving due opportunity of hearing, and therefore they are liable to be voided on the ground of violation of principles of natural justice. First one. He also argues that the very provisions of the Act are not applicable to old structures of the kind, which aspect has not been considered by the decision-making authority. No. 91, I have treated already 2-3 matters. Yeah. First one. Next paragraph. Look at the panel counsel appearing for the BDA opposes the petition, contending that the petitioners have got alternate and more efficacious remedy of appeal against the impugned orders as provided under Section 91, subsection 91(2) of the Act, and therefore they should be relegated to appellate remedy. First one. He adds that
under the scheme of the Act, appeal lies before
Secretary Urban Development Department.
the Secretary, Department of Urban Development, Government of Odisha, who will have accumulated wisdom in matters like this, and therefore this court may not undertake a deeper examination of the same. First, there is force in this submission. Next paragraph. In the above circumstances, these petitions are disposed of, preserving liberty to the petitioners to file appeal against the impugned orders within a period of 30 days, reckoned from this day. First up, registry to return the copies of the impugned orders after retaining copies thereof on the file. First up, the next paragraph. If the appeals are filed within 30 days, the years having been sent in the pendency of these petitions, the same shall be heard without reference to delay and laches. First off, in that connection, all contentions are kept over. Next paragraph. To facilitate filing of the appeal, the BDA is directed not to give effect to these impugned orders for a period of 30 days. 30 days. If already not given effect to, okay. No cost. At least this will help your reply.
Maybe noted in this case.
And write his name in big letters. Yes.
Item 21.
21 has become impromptus.
Learned counsel appearing for the petitioner submits, and accordingly the petition is disposed of as having become infructuous. Yes.
Item 22.
I am reading the matter, but because of my personal ailment, I am not able to face it. A mention was made at the first hour about my ailment. Your Lordship wanted that the matter should reach you, that will record. That's why I have come to make a mention.
You were not supposed to go. You could have spoken from the...
my associate made a mention the first hour. Your Lordship wanted that let it reach.
Okay. I only said, let it reach. I did not say that you should come because persons like you...
That was the impression that it was not...
When do you want, sir?
My lords, any time after second week, there's no after September.
Can we put it in October?
Can it be in the September? You also may fix any time.
No problem. September, third week of September.
Yes.
Third week of September. Please get well soon.
I hope so.
Are you taking medicine?
Yes, my cough and cold.
No, I'm sorry that all the way you have come. You could have said it. I only asked, some madam asked like, I generally discourage adjournment motions in old matters.
Yes,
and I only said that I will give you time, but the matter should reach.
Yes,
because otherwise
he told me that. He told me that let it reach. So I thought that it will not be allowed. That's why I have come.
No, I'm very sorry.
It's communication. Yeah.
Not excommunication. Other friend is not here today. Yes.
Item 23. 23.
Yes.
Item 23.
Yes.
With the filing counter today, there was order for paying cost.
You have paid the cost also.
Yes.
How much cost you have paid?
22,000.
22,000 you have paid. You are rich by 22,000.
No, my lord,
you have to share with
this. My client will take it, my lord. However, I have not received.
This is the communication.
Why he will
transmitted?
You show it to him. You show it to learned counsel.
Yes. They have said 22,000.
I'm serving copy of the counter also.
Yes. Now he is filing the counter. Hereafter counters will come very fast.
My lord, it can be disposed of because your lordship may kindly see.
You don't want to see the counter also?
No, because similar matter your lordship has disposed of. That EGS matter, NFE and EGS matter, your lordship may kindly see.
Copy to that counter, it may help you.
Yes. I am giving a copy. So your lordship may post it to, yes. That's what has happened, my lord, in those cases. They were working as non-formal facilitators for some period, my lord, 3 years, 4 years. Thereafter, the scheme was abolished.
Yes.
Thereafter, another scheme came. Some people were observed in that
matter only. I said,
yes,
new schemes come.
Yes.
On that they may be accommodated.
Yes, similar methods, my lord. Why a third counter is not necessary? In that light, your lordship may kindly see the order passed by your lordship.
Necessary.
Counter. It will be kept on record, but that order will be passed after 1 week also. Same order will be passed because similar matters your lordship has disposed of. 2 matters. Because on the last occasion, Mr. Mahadi is sitting here, my lord. He was there. Your lordship said you have given thousands of people appointment. Why you are discriminating those hardly 20 or 30 persons they were waiting. They are waiting for 10 years, 12 years, my lord. So immediately you consider their case and observe them some other scheme in other scheme because education department they have got many schemes, my lord. And as within 11 years they did not file counter, so your lordship directed you pay 11 into 2, 22,000. And even earlier writ application.
No, you just look into, there are many aspects which are covered.
Yes, my lord.
So there are some resolutions of 2006.
My lord.
All these things you look into. I will also look into my own order.
Yes, my lord.
I cannot be very arbitrary, but at the same time, I cannot lose sight of the contentions which I have paid 22,000 rupees to you to file the counter. So just look into the counter. And I call this matter in the 2nd week of September.
My lord.
The counter filed by learned AGA after payment of cost of rupees 2,000 to 22,000. 22,000 is to the petitioner commands is taken on record. Copy of the same is served on the counsel appearing for the petitioner who wants to look into the same. Okay. Call this matter in this one. 2nd week of September.
Second week of September. Item 24.
Yes, 24. Yes, sir.
It is case, my lord. They are going.
Your best ornament in the court is your smile. Whether dismissed, allowed, smiling will not stop. Yes.
It stems from my heart.
That's how one should do.
My lord, the EGS center was closed on the report of the ADM. On the 1-day visit of the ADM to the EGS center, finding the education volunteer was found absent, he reported that the EGS center was not functioning and for closure of the EGS center. Consequently, that order was challenged before this Hon'Ble Court. May I invite Lordship's kind attention to the order passed by this Hon'Ble Court, my lord. Annexure 11, my lord.
Others perhaps may not wait. This will take some time. About 2-3 serial numbers may sit here. Others need not wait. You can come afternoon. Yeah, you are most welcome to sit in the court hall because I always very happy seeing all of you. But you need not be sitting here. If you have any work, you can eat your lunch at leisure, etc. But yes, about 3-4 persons may sit next in line. Yes.
What
Let's say,
Annexure 11.
what ultimately it said.
Ultimately, the Honorable High Court ruled that the order passed by the collector on the basis of the report of the ADM one-day visit report set aside and matter remanded back to the collector to consider afresh. My humble submission, the collector, what did the collector do, my lord? Again, re-relied the report which was part of the order which has been set aside. This was only narrow compass.
He reprinted the order.
Similar.
Which report was set aside by the court?
The order was set aside. The order
was set aside all right. But the court was also set aside.
Yes, the court held that in view of the backdrop that the order was passed or relying upon the report, that report is itself not sustainable. Therefore, the Honorable High Court says that in view of
where is that sentence?
I may read the lecture 11. Page very important paragraph. Page 45 on internal page 4, paragraph 8. May I read, Milord?
Yes.
Milord, in view of the above.
What is that EGS center?
EGS education guarantee scheme.
Guarantee scheme. Yes. Center in person on the basis of the report of the.
If he is the education volunteer. The second line, the report of the ATM.
Yes, para 8. It finds fault with the report also. Otherwise, it would not have set aside the order. Para 8 of which order? The order dated?
Order dated. We.
4/9/2012.
Yes, madam.
2011.
2nd April 2011.
4/9/2012, na?
4/9.
Is it not 4/9/2012?
4/9 order is of this honorable court.
That's what.
Wherein the order of the collector was set aside. That order is emanated from the report, one-day visit report of the ADM.
Yes, AG, how do you sustain?
My lords, next there was appeal filed against that order, my lords.
Correct.
Writ appeal. And in the writ appeal, this honorable court.
Writ appeal, you had to file.
My lord.
Writ appeal number?
470 of 2014.
That is annexure page
12. 50.
470 of 2000?
2014.
14.
My lord.
Who's
annexure 12? Annexure 12 law. 1-2. Page 48.
What the court said?
The observation was that, my lords, kindly see page 51. Therefore, even if appeal is not entertained, the state is only required to reconsider the case of the original petitioner as aforesaid and no.
Is dismissed.
To reconsider, my lord.
But that is the order made by the learned single judge.
My lord, but liberty was given to reconsider, not that reconsider the case of, and no harm is likely to be caused.
Yeah.
My lord.
It is reproduction of the content of the single judge's order.
My lords, after that, the case
dismissed on?
Dismissed on, my lord.
23/9/2015.
9/15.
Yes.
My lords, after that, the order under Annexure 16 was passed. There was a resolution.
23/12/2016.
My lord. 15, my lord. 23/12/2015.
But you acted upon the same report. You
My
acted
lords.
upon the same report is his contention.
My lord. My lords, that center was closed prior to 2000-2006. In 2008, there was a resolution to observe the persons engaged earlier, but there was a clause. Your Lordship kindly see page 53, para 5. That pursuant to para 5 of letter dated 5/4/2008 of the State Project Director OPEPA that education volunteers.
Absence and non-performance, these are there.
My lord.
But she was a lady. Maybe she went to answer the nature's call and the collector visited.
No, my lord, so it is not like that.
One day, one visit.
Regularly she was not coming.
Where is the finding? Sure.
That is the report of the AD.
Regularly one has to go to answer the nature's call. But whether she went during the duty, sometimes, suppose I also raised.
My lords,
I'm not supposed
my
to
lords,
raise.
they have to facilitate the midday meals and other things.
Correct.
They were not performing at all.
Where is that contention? Where is your contention? Your contention is she was upset when I visited. Or maybe upset even when.
No, my lords. On inquiry, it was found that she is not performing.
Oh, where is that? What is that? She is not performing means what she should do? What she was supposed to perform? The cook food, supply, cater to the needy. That is not the case.
My lords,
She was upset when I
para 5 of my counter, I am placing, my lords.
Para 5?
My lords. It is humbly submitted that petitioner has not been engaged as education volunteer in the another EGS center of this. The additional district magistrate Keonjhar was paid a surprise visit to the EGS center on 25/4/2006 and found that the education volunteer was absent in the school and even she was not coming to the center regularly. She came to the school according to her sweet will. Additional ADM Keonjhar was recommended for closure of the EGS center due to non-performance, low performance, dereliction in duties.
Oh, on what basis this opinion is formed? Where is the material?
My lords,
what notice was given to her saying that, Madam, you have been irregular throughout and you are undesirable in the organization? Where is such notice? Where is such warning? Superior officers to say you are not performing well is very easy. There should be some yardstick, whether she is performing well or not, she is present or not, how many times she was absent. Where is the data? It is not a data-driven order at all. Bold statement, for not performing well, means what? That cannot be. Very vague. Doctrine of vagueness is one of the grounds in administrative law. Any standard book on administrative law like Wade, Massey, Sathe, SP Sathe, all they say vagueness, they recognize in Indian jurisprudence vagueness as one of the grounds for interference of the report. It is very bold. You say
She is
My
not
lords,
performing.
in 2006, the center was closed. They have not challenged that order. Their disengagement was not challenged.
But that is not on that ground you have passed the order. You have passed the order on the ground that she was absent. When he made surprise.
My lords, ground of non-consideration is that as on 2008, prior to 2008, when the resolution came into force, she was disengaged. She was not in service. And that disengagement order was never challenged by the petition.
Where is the disengagement order?
My lords, Annexure A/4.
Since how long she worked earlier? How long she worked?
Yes, since 2002, my lord. She joined 31st October 2002. Let as your lordship saw that the order of the collector clearly explicitly clear that for low performance because of the low performance he was not rehabilitated. Had the center been closed, the unequivocal consequence would have been rehabilitation.
But you are not challenged the closure of the center itself.
I challenge that disengagement. I challenge that order. The collector disengaging the order. I challenge the Hon'Ble High Court to hold that the disengagement closure of the center, that is the closure of the center. Closure of the center on the basis of the report of one-day visit report is illegal. That is the order. The closure of the center are challenged.
What all this center requires? How the center's nature?
Their work is to bring the children to the center and provide midday meal and take care. This is this.
What alternative is made after closure of this center? What would happen to the children?
Yes, that.
Since it was not performing.
It was not performing means she was not performing. She is the only center means she is center.
My lords, it was run by NGOs, my lords.
Run by NGO.
Paragraph 7 of the order is.
And the writ petition was filed in 2021. The closure order is of 2006, my lords.
But that's all right. But in writ appeal, you should have resisted the ground of petitioner, writ appeal, which you lost. You lost writ petition.
My lords.
Suffered writ petition order, you lost writ appeal. So they have some consequence. How many times?
My lords, writ petition order
is affirmed by the writ appeal.
That was to reconsider.
The order itself said reconsider. The single judge himself said reconsider.
Reconsider.
That is because
that, since rule doesn't permit, it was not considered. In view of reason assigned in para 5.
Reconsider in the
on the basis of same report.
Yes. I reconsider in the light of the observation made. Honorable appellate court.
Report, my lord, what I am submit, report had he challenged that report. In 2006 it was passed. And he approached the Honorable Court in 2011, after 5 years. Delay and laches stands.
But that you should have said to that judge.
My lord.
You should have argued that before the other judge, at least in the appeal. Appeal also you lost. Therefore,
in appeal also there was an order to reconsider.
There was order to reconsider is true. True. But you could not have expanded to include other grounds to justify the order which you are going to do. That was not, permission was not granted. It was a remand. Therefore, remand on the basis of the report, you should have considered, you have considered. That report itself is faulty. Because nature calls us.
My lords, consequence of that report was not challenged.
That ground is not available to you because you suffered the writ appeal. The writ petition order you suffered, you lost the writ appeal. Right? Petition is allowed on the following grounds. Petitioner's earlier WP 22096 of 2011 was disposed of on 4/9/2012, setting aside the disengagement order dated
2011.
Made by the collector. Made by the OP collector. First up. The matter was remanded for fresh consideration. First up. Next point. Here the OPs had filed writ appeal 470 of 2014 against the learned single judge's order, and the said appeal came to be negative by the division bench of this court, wide order dated 23/9/2015, observing that fresh inquiry should be conducted in the matter. First up. Next paragraph. The fresh inquiry, so-called, having been conducted, again, similar order is made on 23/12/2016.
15.
23/12/2015. 15. On the basis of the report that was altered by the learned single judge in his order dated 4/9/2012, which came to be affirmed in writ appeal. First up. Next paragraph. Learned counsel for the petitioner is right in telling that all other grounds on which the impugned order is now structured cannot be looked into, since battle lines were drawn when she had filed, his client had filed WP 22096 of 2011, in which she gained victory. First off, therefore, the only point for consideration ought to have been whether the absence of the petitioner on the eventful day of surprise visit.
What is Chari? 24 on 25/4/26. 25/4/06 2006
was sporadic or intermittent. First off, this aspect has not been considered despite remand and despite suggestion by in the writ appeal. First off, at this length of time, all that cannot be gone into. First off, petition is allowed to certiorari issued quashing the impugned order, coupled with the direction to re-engage the petitioners in a similar or such other scheme obtaining in the realm within a period of 3 months. 3 months. First off. No costs.
Sub-item be same, Milord.
All connected matters also same.
My lords, item 25, basic time to file counter, I have informed.
Both the matters to be disposed of by this order.
Yes, my lord.
Obliged, deeply obliged.
Sit. Your lordship, your lordship. Your lordship, and directly remind your lordship to take up, I don't know, 40 days.
Afternoon. After 1 week. Well, learned AGA wants 2 weeks. 25. 2 weeks. That's the request of AGA to file objections. Counter.
So item 29, my lord,
26.
your lordship.
File a reason to rapid date, my learned senior is there, opposite particular. So some other thing.
26 in second week of September on request of. Yeah. Great.
Item 28, my lord.
28.
I will next week, my lord. One by Mr. Das will be taken next week.
In that case, the opposition is not getting paid.
Maybe pardon me.
Monday.
Yeah, we have difficulty this week. We'll have it on 17th September. Up to 17th.
Of course, he is not.
Maybe permitted through issue, my lord.
On that day, we'll this
Interim order continue.
interim order to continue till then.
Maybe permitted through issue, my
29.
lord. Item 29, my lord. Item 29, my lord. Your lordship has 11/8/2025. Your lordship granted me 3 weeks time to file rejoinder, but how it is listed today, though my rejoinder is prepared, but since the petitioner is age older, could not come for sure the affidavit. Your lordship may take it after 10 days at least, so that she could come and swear his affidavit.
Both the sides seek time, and therefore call this matter in the third week of September.
An interim order to be continued, my lord. Grateful, my lord.
Item number 28.
28?
I'm not getting salary for last 1 year.
Oh, 28, somebody mentioned that, no? 17th September we have put that. 16th September.
In item number 30, just now I received a copy of the counter.
50.
Item number 30.
30. You want time in that?
Yes. Your lordship may grant me 2 weeks time to file rejoinder.
No, I'm
The
for the
state.
I have filed the counter.
Copy has been served just now.
Call this matter in the third week of September.
Yes.
I will to pardon item 29, my lord. I am for the opposite party where the petitioner has obstructed my road and not approached to my house, my lord, half constructed house. And in both the courts, he lost the case, my lord. Here he took the time, my lord, because I am in a distress condition, but the obstruction has been made by the petitioner over the road, my lord. Over the road, my lord.
But your complaint is against the member of your bar.
No, I'm not complaining because it is third week of my lord.
Have it on Monday week.
Oh, right, my lord.
May I be
You
permitted?
inform your friend.
Yes, I will. But he didn't inform me when he mentioning, my lord.
Yes, sir.
May I be permitted? Make a small mention. Yeah. Item 42 that relates to the admission of the student in class 6. My lord, that posted it specifically yesterday. It could not reach. It will only take 1 minute. The instruction I have. Can it be taken up as last case if it doesn't reach?
Well. You just mentioned because it shall be raising by 245.
Because of the reference.
Because of reference.
Before that, this country.
We do that.
40 is to also be taken.
Nani is here. Wait.
I may be pardoned, my lord.
Yes.
Item number 37, my lord.
Nani should never say, I may be pardoned. You should look at me as younger brother. Nani is very strangely is a elder sister. But in Hindi, we had very long ago. So we had some Hindi lessons wherein Nani meant maternal grandmother. Anyway.
Item 37, last week I have
37?
received, my lord. There
What
are
do you
two
want?
matters. I have received the counter last week, my lord. I pay for time to file reply to their counter.
When do you want to file?
Your lordship may kindly.
But has filed the counter.
It has filed the counter. So reply you want to file.
Yes.
Whether
Kindly be taken up, my lord, any date in September, my lord, because.
On 18th of September?
My lord.
All right.
Yes.
Will you inform your friend?
Government is the.
Government is. All right. We'll call this matter on 8. Or can it be?
Or before that, my lord, there is an interim order, my lord.
There is interim order?
Yes, my lord.
In your favor?
Well, let it be on 8.
Then let it come in the second week of October.
No, my lord.
But you are enjoying interim order.
No. For not taking any coercive action, but the benefit of nursing home.
All right. On But up to 17, we have.
Let it be 18th.
18th. We will have it on 18th. Alright?
And the internal can be continued.
Interim to continue. Yes. Huh?
Special notice.
Special notice. A fresh matter. Yes, matter. So yes, certain one.
Please, Your Lordship, my lord. My lord, the petitioner is a disability person having locomotor disability of 60% under Annex 1. Your Lordship, can you have a glance?
60% he has?
He has 60% permanent disability. Then, my lord, he is now the assistant teacher in a primary school and working in the under Rajgobindpur block in Bandhamundi government upper primary school, my lord. The government.
How many years of service he had?
He has, my lord, first he was Sikha Sahib, then became junior teacher. Now he is a level 5A teacher.
8 years.
Level 5A teacher. Therefore, he was posted in it.
No, how long he has been in service?
In total 11 years.
11 years.
Yes,
in the same place.
No, other places now in after regulation in his village, my lord. In nearby posting.
When regulation happened?
2018 or 19, my lord. I have not exactly read. Here what happened, my lord? That government issued a circular on 13/5/2025 at page 12 under Annex 2 that local MLAs and MP they will recommend for transfer of the in 15 cases, my lord.
Issue emergent notice. Stay of impugned order of transfer so far as petitioner is concerned, coupled with a direction to continue him in the very same school when he was working before the transfer order was issued, till next date of hearing. Call this matter along with WP number.
Along with WPC number, my lord, your lordship judge. I'm giving.
Give that copy.
I will give the number. Copy. I will give them. I will give the number.
Let that copy be sir, because it is a special mention matter. We don't have any.
I have shot the copy.
Sir, one more copy.
More copy, I will shot. I'll not the certificate copy.
All those matters I am posting on particular day, so that collectively I can hear and dispose of once for all.
And this circular was superseded by the government in subsequent guidelines.
Now we have already been granted the interim relief.
Yes, ma'am.
Once interim relief is granted, further argument should not.
No, not.
But it may dilute it.
No.
The very
yes,
cases. Okay. Next.
Item 27. Number 27, may I please, Your Lordship?
Yes.
Lordship, the background of the case is that, my lords, the petitioners are the permanent residents of a village called Ainginia. And what has happened is, my lords, there is no road which will connect to the area of the residential area of the petitioners.
No road.
No road.
How? Slowly.
Yes, my lords.
You have to take me slowly.
Sorry, my lords.
There is no road.
No, my lords.
Which is your village?
Ainginia. The details, my lords.
Engineer. Sounds like Irish name. Yeah.
So what has happened?
Bhubaneswar Tahsil.
Yes, my lords.
No road.
No, there is no permanent road to that area. What has happened?
How people go and come?
Previously, my lords, we had filed one WPC in which we prayed for a permanent construction of road. In that WPC, my lords, the government had filed one joint affidavit saying that on plot number 347 and 349, there is a connecting road which you will use for your ingress and egress. That plot number 347 and 349, my lords, these two are the private plots.
Private plots?
Private plots. To that effect also, I have annexed the document showing that these two belongs to the private parties. So how...
Slowly. You have to halt after one sentence. So, what the court said?
So, the court said, that is my whole difficulty, my lords, that At paragraph 17, my lords, page number 13.
On private plot without having any right of petitioner to use the same. Now, what the court said?
The court's order is, my lords, at annexure. Minutes, page number 12. I have quoted the order of the court. The relevant page, para, is at para 1, page 12. Shall I read it? Page number 12, my lords.
Plot number 3%, the joint field inquiry report also reveals that there is unhindered access to petitioner's plot and hence their prayer to use plot number 348 as what appears to be unwarranted.
Yes. Why, my lords? Because at that point of time, it was not known that 347 and 349 are the private plots. As because the government gave the affidavit, the petitioner and the court innocently passed the order that 347 and 349 can be used as further ingress and egress.
But this order was made on which day?
This order was made on
28/11/22.
Yes, my lords.
Almost 3 years are over.
Yes, my lords.
Yes.
After that, my lords, we had given several representation saying that when we got to know that 347 and 349 are the private plots and we cannot use those plots because
That contention you had already taken.
no.
No, there is a counter affidavit saying that they are private plots.
Counter affidavit.
Anyway, you have suffered an order.
Yes, my lords.
Maybe in your favor for some time. Now you are feeling difficulty with that order.
Yes, my lords.
You go and seek recall of that, a review of that order on the ground that government misled the court. One more writ petition cannot be. Res judicata comes in the way. It's a ground under order 47 rules, rule 1 of CPC. I will make some observation. Under the shadow of that observation, you go before the learned judge. You want approval from your senior?
Yeah, I just
Otherwise, even if I direct them to consider the representation, they will say considered and rejected because of this court order. That will not help you. It will bring one more case to you. Of course, it will be profitable to you. But to us, it will not.
No, what had happened, my lords, after that, after this joint verification, plot number 348, which is the cremation ground. There is a cremation ground and that cremation ground is being used by all the residents of that area. Now, we had given the representation that at 348, as it is a cremation ground, give us a passage of road which will be accessible to us. But in that cremation ground, millets, they are constructing the boundary wall. They have started the boundary wall. That is my whole difficulty. So if it is completed, then the petitioner will have no options. For which your lordship...
Mr. Mohanty, having told the court that 348 and 349 they can make use of, now if you put the boundary wall.
Boundary wall is meant for that particular cremation ground.
Then you should not have said you can make use of this property.
But earlier occasion, while considering the same and the joint verification report, this has been vividly discussed. So far, the page 46 is concerned, wherein order was passed me.
46.
But page 46, it is of order dated 30th October 2021. Clearly, the same has been mentioned, my lord.
Saying that you can put the boundary wall.
No, man. The private plots. This is the ingress and egress to the private plot, my lord. What, my lord, the fact remains, in Bhubaneswar area, the builders when coming to the making a landscaping of the things. So without even making roads, they are allotting the plot. That is what the crux of the point. So the land which has been marked for a specific purpose, this has to be...
That is the general principle is true. But you have to leave. Otherwise, you have to provide one helicopter to everybody.
Because so all other plots are private plots.
We do not know. You made that submission before the court. Now, at least some passage for them to walk to their house and from their house to other places, the milk booth, school.
Yes, my lord, only the others are Bhubaneswar municipality. They are the panel of lawyers,
will issue
who are exactly.
Notice has been issued. On 17/8, notice has been issued. But no one has acted because notice.
You bring somebody.
Because notice will issued by BMC to their respective lawyers.
So tell them, otherwise how can I pass?
In presence, if
on this ground only I can reject your
then it
petition.
can be sorted. If at all the lower concern from the Bhubaneswar municipality will be here, then things can be sorted out. Not by issuing notice.
Our objective to do justice to the litigant, not bringing judgments, long judgments with no elements of justice. What is going to help the litigants? Litigants come to court because they have faith that court will do something, not writing judgment, not writing thesis. Therefore, go and bring your friends. Then I can make that some observation. I may
so far, OP number 4 is concerned. They're in BDA. Mr. Dayanand Mahapatra, day in and out.
Dayanand Mahapatra, learned panel counsel, is requested to appear for
OP number 4 BDA.
OP number 4.
And 3 is their panel of lawyers. They can set it out and serve the copy. No issue.
Petitioner is permitted to serve a copy of the petition along with all the documents on one of the panel advocates of OP
number 3, that is Bhubaneswar Municipal Corporation.
BMC.
Yes,
BMC. Post this matter in the second week of September.
Let's in IA number 142.
We will not halt anything.
Because Millet's construction has already been started.
Let it be completed. You can walk on the compound wall. Yes. Item 31.
But in this case, I appear for the petitioner. You will also kindly see the noting. There are also some others who have intervened by filing an intervention application, but I think nobody is there.
Intervention.
Although I have brought that objection to that intervention, that is with regard to that noting. And so far as the two private opposite parties impleaded by me are concerned, nobody has appeared for them as is revealed from that note sheet.
They are served with the notice.
Yes, that is what the notice in the cause list indicates.
That was notice on application for impleadment. No order is passed on impleading.
My lord, I had impleaded originally 2 persons, opposite party number 3 and 4. Notices were served upon them, but nobody appears for them. That is what the noticing indicates.
OPSC, their panel of lawyers.
No, OPSC is being represented.
Okay.
4 and 5. 4 and 5. The OPSC is 3. OPSC is the proper party, reason being, here I am challenging the gradation list and the consequential promotion, which will ultimately be approved by the OPSC. That is why a proper party I have implemented for abundant caution sake. But there are 2 substantive parties made by me, that is OP number 4 and 5.
They are not represented.
They are not appearing, as is revealed from the cause list itself. But another person who has tried to intervene by filing an intervention application, he is also conspicuous by his absence. Today he is not present, even if I have come prepared with the objection to his intervener because intervention application, because he has already retired and he has got no axe to grind against me, because he is virtually claiming the very same thing what I am. Instead of filing a writ petition, he
wants to intervene in your
intervene in my case.
He wants to take bath under the leaking umbrella of yours.
And your lordship knows better. An intervener cannot ask for any prayer.
But he is not here.
He is not there. So I am not making any submission there. Here, my lord, in my case.
So why are you arguing in their absence? They should hear your argument, na? Or you have told them not to come here?
No. With regard to intervention, I am not saying. I am saying on merits. If your lordship gives me indulgence, then I can address your lordship on merits.
But the other side has to be here, na?
My substantive opposition party is the state.
Maybe.
They have filed a counter. I have filed my rejoinder. The pleadings are otherwise ready.
You bring your friends also. Offer them cup of tea along with upuma. They will come. Otherwise, they will not come at all.
Can I file my objection before the court to that intervention application, which may be taken on record? And I am serving a copy of my objection as well.
Objection to intervening application
To the state?
is taken on record. Filed by the petitioner is taken on record. Petitioner to serve copy of the same on the learned counsel representing the intervener.
My lord, if you
to supply copy to it.
Your lords may kindly observe that despite notice, nobody is appearing. Because, my lord,
Suppose if they come and tell me in your absence, how you will feel?
And let that
Let it, we should not make that. Anyway, we are not deciding the matter, but let us see. Next date we can say that you can serve the copy. Well, we should not write orders of the court with the pen dipped in acid. It should be written only with ink. Is it not? There are orders where we should write with acid, but otherwise with ink we are writing the orders.
Why
we are not human beings.
why I requested your lordships, tomorrow they will appear on the coming date and they will again take this plea that since it has been served on today, we will take further time.
Let us see what will happen tomorrow. Nobody knows. Yes.
My lord,
September.
Third week of September. Oh, blessed. To enable all other counsel to come and argue.
Okay.
This much we can say.
Oh, blessed.
Item 32.
Sir, I file this writ application for challenging the order dated order under Annex 8, 7 and 8, Lordship. Whereas petitioner has been allowed the
Where is your friend? Who is your friend? Any inimical friend?
My lord, state as well as the other parties, my lord, they have entered appearance on behalf of OP number 4.
For the management, Lordship, they have said that he is working under my school and he is, in the meantime, 30 years has been elapsed in the service period. For the RSCP of 10 years, 20 years and 30 years has been completed, but I am getting the 10 years RSCP, Lordship.
20, 30 you are not getting.
20 and 30 I have not.
You have put in 30 years also.
Yes, Lordship.
What is this, brother? 30 years you have sucked his blood and you don't want to give. 30 years.
And file
perhaps nobody has put so long a practice in my court, perhaps.
Here is Lordship
30 years service.
Annex 9 Annex 9. Lordship, Annex 9 in my districts, other have been allowed. That is, I have filed here. Annex 9.
But to you, they have not given.
Yes, Lordship. I am from 2016. I filed
the judgment.
2016. I am filing. I have filed the writ application.
What happened in that WP 31901 of 2021?
That one, Lordship, it was disposed of that I have not challenged the rejection order of the OP number 3, Lordship. That one I have challenged in 2022. Again, that was also disposed of. I filed the contempt, first contempt was filed. Second, when I filed the second contempt, at that time, they filed a succour that you will not get the benefit as your RSCP, as your BD was from 1/10/1994 instead of 1/6/94. We came in the granted fold only.
We'll file counter, We'll file a counter.
What to file counter? Counter to be filed within 2 weeks, failing which right to file one stands for appeal. This is how many times he has to come before the court?
2016 I am here. 2016 I am here.
We derive a kind of sadistic pleasure in driving the people to this court again and again.
Yes.
There is a kind of sadistic pleasure here also, so that people can come here, stand before us and cry before us. Then they will go without some orders.
Yes,
so this has become the order of the day. How many times a person should come to court? How many years he has to spend the time in the years in the corridors of the court? Mr. Mohanty, this building is cursed by many litigants. Many litigants have cursed this building. Nobody will be, if they are going in front of the court, they will turn the face other side and they will move there in their vehicle. They don't like to see this institution. Yes. Tourist. Okay. Next.
Second week of September.
Second week of September.
Item 33. May I please? Here, my the petitioners, the short remand of the petitioner, my lord, even though the petitioners were appointed prior to that, GPF rule, amended rule came into force, that is prior to 1/1/2005, but their services has been approved after 1/1/2005.
Similar matters we have already.
No, this is not similar.
Not that.
Not. Here, my lord, already approved, already brought into the fold of granting aid. Now the authority, by misinterpreting the provision, statutory rule, denied for allotment of GPF account number only on the ground that since even though you appointed prior to 1/1/2005, but you have got the benefit of granting it after 1/1/2005, therefore your allotment of GPF number cannot be granted, even though others have been extended. My simple prayer, yes, in the very imping order they have stated so. Out of 8 employees, 6 employees they have allotted, only 2 employees the present petitioners.
Mr. Mohanty, take.
And I am relying the rule. You also kindly see for a moment the rule. Rule is very clear. Apparent, also kindly see for a moment. I have quoted the rule, will also for time convenience.
Let us ask. Now I am convinced that now he has to say something.
Yes.
Na?
Yes.
Sir, my lord. So
You have given it to others.
My lord,
Their names
but
are
only on the
very
ground
equal
that the completion of 1 year. Can you have a glance to page 39 for a moment?
39.
That is the impugned order which is under challenge. '39 is a letter dated 16/9/2023.
Yeah. What is the ground on which you have?
Exactly, manner. That reasons for non-allotment of the GPF account number follows as under. These are the reasons, manner. So, made the Vara 1 subpara, manner. In this regard, it is to clarify, along with the government orders circulars, if any, whether the employee is receiving GIA after 1/1/2005 being appointed or joined in the service to 1/1/2005 are eligible to govern under the old pension and the GPF rules.
Let us see the rule position.
Yes. It's kindly see that education manual, page 819. 819 page.
819.
819. This is the rule called Odisha Aided Educational Institution Employees General Provident Fund Rules 1983.
Which rule?
This is the rule, my lord, governing the field, which is called as Odisha Aided Educational Institution.
That I have held now.
Rule 4, my lord. Rule 4. It said, my lord,
temporary
employees, including probationer after continuous service of 1 year, and all permanent employees shall subscribe to the fund, and joining of fund shall cease to contribute the contributory provident fund or any other fund. Next is proviso. Important. I am coming to proviso. Next page, my lord. Provided that these rules shall not apply to the employees appointed on or after 1/1/2005 to receive and post in non-government educational institution, either temporary or permanent. Now my appointment, they have not disputed. I am appointed to prior to 2005. They have approved my service by mentioning my date of appointment and joining prior to 2005. Only, my lord, as per the granting of principle, one employee after completion of 3 years in respect of colleges who is situated in educational backward district and in respect of colleges which is situated in educational advanced district are eligible to get the benefit of granting it after 5 years or 3 years, as the case may be. Therefore, the word is very clear that these rules shall not apply to the employees who are appointed after 1/1/2005. Here, my appointment of both the petitioner much before to 1/1/2005.
Yeah, you have said it.
Yes. Now, my lord, they have rejected my case annexure 6. The only reason they have stated para 1, Dilip Kumar Devta and Lingaraj Nag have joined in their service with effect from 30th April 2003 and 14/9/2001 respectively. But they have received GIA with effect from 1/6/2006 and 1/6/2005 respectively. That is after 1/1/2005. So they are not eligible for allotment of new GPF account number. My rule is saying something
in view of FD letter number.
Yes.
Dated 1870.
Yes, yes, that is also I have enclosed Annex 7, page 41. Even that circular of the finance department never says so.
Page 41.
41. Plus, you kindly relevant para that 41, Annex 7, para 3.
This letter is issued by whom?
By the
Deputy Secretary of
government is a
Department of Finance.
What it says?
Well, para 3 is relevant for the present case. Similarly, in case of teaching and
slowly.
Similarly, in case of teaching and non-teaching staff of aided educational institution who are working in pensionable establishment in the event of taking over of such aided institution by the government on or after 1/1/2005, their cases will be governed under the OCS.
Will also be governed.
Yes. Under the OCS Pension Rule 92 and existing GPF Odisha rules would also be applicable to them. The rule is that letter is also whenever
it's supposed
yes. And this is not said that I am not eligible. And more particularly, the rule is very clear. And they have interpreted that rule that only I received granting it after 1/1/2005. Therefore, I am not eligible.
There is one good book.
Well,
Elements of Legal Style by Garner. You have to read that. He says where we should put the comma, semicolon, full stop.
Yes.
You are doing very well. But the comma, full stop, all others, they are lacking.
I was very sorry, therefore I am.
That is no ground for ignoring the symbols.
Yes,
Live by symbols. First, you should make a statement. Allow the judge to process.
Yes.
Okay. Judge may not be intelligent, unlike you.
No.
So you have
day by day we are learning much more.
After making one statement, to keep quiet, you have to assess. This is what Osho tells in his Art of Communication. After making a statement, you should wait to see what impact your statement has made on the mind of the addressee.
Yes.
Then construct another sentence. But in that, ear should not be asking another thing. No, we should go that way. Yes, Mr. Mohanty, regardless of his gate crashing all symbols, grammar, there is force in his submission.
My lord, may I read the same, my lord?
Read.
Similarly, in case of the, I am reading, my lord, page
in case
41.
of teaching and non-teaching staff.
Exactly. Staff of the aided educational institute who are working in the pensionable establishment in the event of taking over of such aided institutions in the government on or after 1/1/2005, their case will also be governed under the OCS Pension Rules 92 and existing GPF rules would also be applicable to them. I am coming to the next one. Now the AG&E, Odisha has brought to the notice of the government that while sending the application of the above category of employees to the AG, A&E Odisha and Controller of Accounts Odisha, as the case may be, for allotment of the GPF account number in their favor, concerned DDO are not indicating the reasons for applicability of the GPF rules in respect of such employees. The AG Odisha has further pointed out that some of the DDOs are sending application of the new entrants to the state government, service of the allotment of the GPF account number in favor of such employees, even though the existing GPF rules are not applicable in case of such employee joined in the state government service on or after 1/1/2005.
That's what
Here, my lord, the petitioner is coming under to the
2005.
2003 million.
Yes, therefore before 1/1/2005.
But receiving the GIS in 1/6/2006 and 1/6/2005 million. For that purpose, my lord, they have filed the GIA case then subsequently FO before this Honorable Court, then SLP, then my lord review, and after that, finally, the same has been decided on 8/9/2022, my lord.
8/9/22 against the petitioners.
No, my lord. The state has gone for SLP, my lord.
It has gone for SLP.
SLP.
When it was SLP is filed when?
SLP is filed, my lord, it has completed in 2017. Then, my lord, review was in 2018.
SLP went against you.
Yes. Against us, my lord.
And you have
because we have traveled in SS.
But in terms of that, you subject to outcome of the SLP review, we will allow this.
But only on that ground that for that 1 year, because we are making it clear that they received the GIS since 2006. Ma'am.
Anyway, that contention is rejected by the apex court while dismissing your SLP.
Yes, ma'am.
And you have filed review. Thereafter, if you rejected, then curative petition, and that will take
completed in 2022.
Against which order? Is it covered by the judgment?
No. This the previous round of litigation is against regarding non-approval of my services.
Not with regard to this
GPF, because unless I brought under the fold of granting it, I cannot eligible to be.
Which rule says you should be permitted to join the GPF with effect from the date which you are now mentioned?
In that GPF rule 1983.
1983.
Rule 4 proviso.
It says these rules are not applicable.
Not applicable. Those were appointed after 1/1/2005. My case
is all right.
Yes.
Therefore, we have to keep those rules aside now.
Yes.
What is your right?
No, my right, my lord. My case is governed under this rule because I have appointed and joined much prior to 1/1/2005. Therefore, while others employee, they have extended the GPF number.
I not understood. You said these rules are not applicable to you because you are appointed before 1/1/2005.
Before, after, the word is after.
You are appointed before it.
Before.
3. Therefore, these rules are not applicable. Applicable.
Yes.
Which is that rule you said?
The proviso also kindly see, provided that these rules shall not apply to the employees appointed on or after 1/1/2005. Because those are
others they apply. Means those who are appointed before 1/1/2005, they are governed by.
Yes, I have been appointed prior to 1/1/2005. And they have extended the benefit in respect to Perisam College. They under the imping order itself, they have allotted the GPF number. And I have sought citation regarding that interpretation. They have if the rule is very clear and unambiguous, they cannot interpret in the other way. Then number of
we go to interpretation only when the text of the law is not speaking properly.
Yes.
If it is very clear.
Yes, that is the entire judgment, my lord. Through 2, 3, 5 Supreme Court judgment, I have
happiness.
Yes.
Right. Sit down. Please sit down. Mr. Monti, this is a matter where we have to grant relief to the petition. Yes. Yes. Sit down. The next time when you come, you have to show that book to me.
Yes.
Elements of Legal Style.
Yes, sir.
By Garner. Right. I am reading that book now. Therefore, I told you. Yes. 34. I have the education with. He is more in a hurry than you. Because time is running out.
May I please, your lordship? Lordship, I am appearing on behalf.
Wait. Perhaps I'm not. I don't think that I will be able to take up other matters because we have to go to reference also. Kindly do not disturb me. I am framing my mind for framing the judgment. Take up. Petitioners. Only one petitioner.
Two petitioners.
Two petitioners.
They are working as what?
Lecturers in 2 departments, that is.
One is the history and another is of political science.
Political science and history.
Right. First petitioner is appointed on?
Appointed on
14/9/2001.
Yes. First petitioner, my lord, 14/9/2001. Second petitioner is 30th April 2003.
Subject is political science.
First is political science.
Political science.
Second one is history.
History. That is available on page 37, the approval order itself.
Okay.
The date is different.
First petitioner was appointed as a lecturer in political science by order dated 14/9/2001. First one. The second petitioner was appointed as a lecturer in history by order dated 30/4/2003. First one. Both they have presented this common petition to call in question the order dated 14/11/20.
16/9, madam. Annexure 6. Annexure 6, 16/9/2023.
16/9 it is. Yes.
Annexure 6.
16/9/2023 at Annexure 6, whereby the Deputy Controller of Accounts, Odisha, has sent an intimation to the Accounts Officer of Department of Higher Education, Bhubaneswar,
Para 1 is in there.
to the effect that petitioners are not eligible for allotment of new GPF account numbers in view of FD letter dated 18/7/2007. First off. Next paragraph. Learned counsel for the petitioner vehemently argues that his clients have eligibility to the allotment of GPF account numbers in view of Rule 4 read with its proviso of OAE IEGPF Rules 1983. Generally, in your state, the title of statutes and rules are one furlong at least. 83. First, he also tells that other similarly circumstanced lecturers have already been accorded such GPF account numbers, and therefore his claims cannot be treated stepmotherly at the hands of jurisdictional organs. First. Lastly, he submits that the text of the rule being as clear as Gangetic waters, does not admit any interpretation. First one. Next paragraph. Learned AGA appearing for the OPs opposes the petition, contending that it is the policy of the state that only a class of employees are entitled to allotment of GPF account numbers, and that the petitioners do not fall within that category, and therefore no fault can be laid at the threshold of the officials who have structured the impugned order, rejecting claim of the petitioners for such allotment. Next paragraph. Having heard the learned counsel appearing for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter for the following regions. First one. 3.1, 4.1. The petitioners have been working as lecturers prior to 1/1/2005, going by their dates of appointment cannot be disputed. First off, under Rule 4, read with proviso of the 1983 rules, a right is created in favor of the petitioners, for the grant of new GPF account numbers with effect from
Their date of appointment, ma'am. The date of
effect from
respective date of
their respective dates of appointment. First off, the text of Rule 4 is as under. Full Rule 4. Next paragraph. Learned counsel for the petitioner is more than justified in telling the court that the rule being as clear as a crystal, it does not need any interpretation. First, the benefit of rule extends to all those who have been appointed prior to 1/1/2005. First off, the proviso to the said rule, which is reproduced above, needs to be treated as an exception to the rule, consistent with the decision of the apex court in so and so, which decision? The proviso should be treated as an exception to the general rule. There are judgments.
Yes, that cannot be read isolation.
Not isolation. Rule?
Yes.
Proviso is an exception.
Yes.
And there are exceptions to this rule also.
Yes.
Okay? Take out that judgment from GP Singh's interpretation of statutes. Okay? The proviso excludes only employees who have been appointed on or after 1/1/2005. That is the date on which these rules came into amendment. This amendment to the rule came into effect. First off, denying relief to the petitioner cannot be sustained without manhandling these rules. Next paragraph. The contention of learned AGA that in the FD letter number 30447/F dated 18/7/2007, certain parameters have been prescribed and that petitioners apparently do not fall into that, and therefore no relief can be accorded to them, is very difficult to agree with. First off, the said letter, which is that annexer,
Annexer 7, 18/7/2007,
is produced by the petitioners at Annexer 7, wherein paragraph
last paragraph is also stated.
Last but one.
Yes.
Last and last but one.
Yes. Yes.
The last and last but one. No, last but one. Now the AGAE, that paragraph.
Yes.
Or similarly in case of teaching and non-teaching.
That also that the next paragraph is also
now
Similar.
Now the AG into brackets A and E Orissa, it begins like that. This is unnumbered 1, 2, 3, 4. Unnumbered fourth paragraph in the said letter, which reads as under supports the case of the petitioners as against that of the OPs. First, next paragraph. In the above circumstances, this petition succeeds. Semicolon. The impugned interdepartmental communication dated
16/9/2023.
16/9/2023 at Annexure 6 is a recapitulatory issues quashing interdepartmental communication dated 16/9/2023. 23. Semicolon. The writ of mandamus issues to whom?
OP4, the control of account.
OP number 4 to allot
OP number 3.
OP number 3 to allot GPF account number to the petitioners with effect from the date of their respective appointments. But how can be issued with retrospective effect? Who would make the contribution? Nothing. All three have made the contribution.
Yes. We
will only say allot the account number.
Yes. Yes. As an extended to others.
Account numbers within a period of 6 weeks. 6 weeks. Full stop. Default or delay in complying this order shall be viewed very seriously at the next level of legal battle, if petitioners are driven to.
RSCP matter मेरा cover matter.
Item 38, item 38, my lord. Cover matter already you will.
One day we are again coming back now. Enjoy the festival. Are you not enjoying the festival?
Yes.
I am receiving letters from children and spouses of the lawyer saying that tell our papa to spend time with us. I am receiving the letters.
May I submit 1 minute? One matter is at serial number 36. I am conscious that a person who is arguing in person, that letter of land acquisition which has been sent to the districts Hon'Ble and Dhenkana, it has been duly communicated. But I think for him at least date be fixed, by that he will not be harassed.
You are.
I am on the
who is that? Is he here? Please come. You should thank the government advocate for his fairness. 36, sir. We will fix this. Brother, आपका नाम क्या है?
रॉबी नारायण पुष्टि मिलर.
रवि नारायण, आप कहाँ से आते हैं? भुवनेश्वर से. भुवनेश्वर.
It is let it be second week, any date मिलर 9 or 10 date be fixed by that.
So that he will know. Exactly. On 11th को आ सकते? Call this matter on 11th.
My lord, wanted me to remind that admission matter. Time is over.
My lord, item
42.
My lord, item lordship order. Similar order.
Monday.
Say like that.
Monday, my lord.
Monday.
Can we have Monday?
Monday, my lord. 40.
Those covered matters also.
My lord. 38, my lord.
All the similar.
My lord, item 40. My lord, I love item. My lord, item 40, my lord. Your lordship wanted to dispose of today.
40 is what urgency? What is
my lord, the petitioner has been, his salary has been
salary is halted.
My lord, your lordship. No, my lord, your lordship directed me to remind because your lordship apprehended that some kind of trickery will be done.
Tuesday, that matter.
Madam,
The matter not Tuesday.
40.
Okay.
Which other urgent matters? No urgent matters. All right. Are you not joining there?
Yes,
Come then.